Properties resource consent application. First introductions, my name is Andrew Henderson. For those I haven't met, I'm a planner employed by Jacobs but retained by council to be an independent commissioner for this hearing. These proceedings are being live streamed. There's some interest from some members of the public, I understand, and also council's lawyer will be streaming in. So if you don't want to appear on camera, I think those two seats there are on screen. So yeah, just as long as you're aware, we've had hearings before where people didn't want to be on camera.
I'm in now. Yep. Okay, thanks, Brent. Bye.
Okay, cheers.
For the benefit of those online, if there are others watching, this is an objection. It's not a full hearing, so it's not a relitigation of the entire application. I think it's important to know. Process-wise, we'll run the same as the hearing. Though we'll hear from the applicant, then we'll hear from the council. Then we'll have a discussion after that if there's adjournments or extra information that's needed. I assume most of you will be familiar with the council building. You know where the toilets and facilities are. We've got the room all day. I don't think we need. Well, I guess nobody wants to be here all day, but we've got as much time as we need. So we'll see how we go time-wise to take a break about 10:30ish for a break if we need to. I don't think there's any other procedural matters that I needed to cover off. So in that case.
Thank you, Commissioner. I thought I might introduce the team and just give you a general outline of what we're going to do today so that we can all get a general idea of timing and what it is that you are likely to hear. So my name is Jo Appleyard. I'm appearing for the applicant Braeburn Property Limited. And I just want to stress that Braeburn Property Limited is the landowner. It is not the occupier of the site. It is not the party who carries out activities on the site. That's particularly important context for this hearing today. I've got Lucy Forrester with me, assisting me. Now, I might just introduce the other parties who are in the room and just explain what it is that they are going to produce and how they fit in. So, Richard Peebles. Richard, you can introduce yourself. So, Richard is the representative of the applicant who is the owner of the site. Is there anything else you want to say, Richard? No, that's and he's going to present a statement around his issues with the conditions, and in particular from the perspective of a landlord who may well have tenants that aren't doing the types of activities that SCS are currently carrying out on the site. That's quite an important matter for the owner as applicant. I might just get Aaron to explain his roles. So Aaron Temperton, isn't it? Sorry, Temperton is here representing the current tenant of the site, SCS, but Aaron is not here as a representative of the applicant. It is just an example of the activities that are currently being carried out on the site. And Aaron's got some evidence that he's going to give in relation to the current activities on site. That's summary of where we're heading. Yeah. Sam, you might like to introduce yourself.
Sure. My name's Sam Jackson. I'm an acoustic consultant with Al Fenwick, and I've been acting as the acoustic consultant on this project for the last couple of years, working both with the landowner Braeburn as well as with the occupier with Aaron Templeton to provide design advice around activities on the site as well as take noise measurements.
And Sam's got a statement that he's going to present today too. Sure. And Tim.
So I'm Tim Walsh. I'm a planner with Novo Group, and I prepared the resource consent application and have been involved quite a long time now. And I have a statement of evidence that I'll read later on.
Okay. And Ben and Mark, do you just want to introduce who are interested parties here to watch, not presenting any evidence?
Watch.
Yes.
Yeah. Work with Richard.
Okay.
So just in terms of what we've got to present today, we'll get through some legal submissions from me that are 16 pages. We'll then hear from Richard Peebles, then we'll hear from Aaron Temperton, then we'll hear from Sam Jackson, and then we'll hear from Tim Walsh. That is how I intended to approach it.
Sure, that's fine.
I don't know if the council team want to introduce themselves now or.
Sorry, would have got there.
I'm Rachel Wilson. I am the processing planner for this subdivision land use, and in the screen is Andrew Green, who is council solicitor for the day. Anything else to add, Andrew?
No, Rachel.
Cool, perfect.
Thank you.
Thank you. Right, you should have a set of legal submissions from me. Andrew, I've just realised you won't have these. Would you like me to see if Lucy can email them to you?
Yep, that'd be great, Joe. Thank you.
Yep, thank you. Sorry about that. I had forgotten about the logistics of you being on Zoom. These legal submissions are made on behalf of Braeburn Property Limited, the applicant, in respect of an objection to conditions, the objection on a decision in relation to an application for resource consent to authorise the following activities at 320A Cumnall Terrace, Woolston. And it is quite important to focus on what the application was actually for. Firstly, it was to enable works, to enable industrial activities to be undertaken within the site. Secondly, it was to allow use of a sealed area within the landscape and stormwater area, which we describe as green space, shown on the Portlink Industrial Park ODP for activities permitted in the Industrial General Zone, Portlink Industrial Park. And it was to deal with a boundary adjustment primarily for the purpose of vesting an Esplanade Reserve. So it was quite a limited application in terms of what it was seeking to authorise. Then jumping back down to paragraph 3, it is particularly important in the circumstances of this objection to consider or understand the context in which the application was made by Braeburn. The site was initially zoned for industrial purposes in 2010 and is currently zoned industrial general zone under the district plan. The applicant is the owner of the site, and that's particularly important. The full extent of the site, subject to the application, is shown in red below. Now, SCS is the current tenant, so it's the occupier, and they lease yards 3 and 4 of the site only, as shown in the figure below. And SCS has operated a shipping container depot on yards 3 and 4 since July 2022. Tim Walsh, there's nothing you wanted to explain in relation to those diagrams at this stage?
Only if there's any questions about it.
Probably not. Up until 2022, the site remained vacant and was grassed with open outlooks, and that's obviously what the residents would have seen, notwithstanding the zoning. We understand that since the establishment of SCS's depot, the council has been receiving complaints from residents in respect of SCS's shipping container activity. Those complaints relate to a wide variety of issues, including visual amenity effects, safety, glare, as well as noise, which is alleged to emanate from the activity. And I'll just stress the alleged there because Mr. Temperton's got some information to give you on that. Now, on 27 October 2022, the council issued abatement notices to both Braeburn and SCS, and it's important to understand what those abatement notices related to. And Braeburn and SCS were asked to remove and not to recommence placing any items, including shipping containers, hard stand areas and fencing that are not landscaping. They're asked to remove those things from the part of the landscape and stormwater area green space of the ODP. So it related to the placement of things, if you like, in that green space area. That was the limit of the abatement notice. The abatement notices related only to activities being undertaken or that had been undertaken in the green space of the Portlink Industrial Park ODP. Now, separately from the abatement notice issues, Braeburn and SCS were also having discussions with the council about whether the shipping containers on the site were buildings within the definition of the plan, which were exceeding the 11-metre building height limit area in the development ODP. The issue is that the parties have different views on the interpretation of definition of building in the district plan, and therefore whether transient shipping containers stored on the site are a building or not, and therefore whether they have to comply with the 11-metre height limit. The abatement notices, however, and this is really important, did not assert any breaches of the height limit for buildings in the plan. So the abatement notices were limited to those particular matters about activities taking place within the green space area. So following meetings with the council on 14 November 2022, Braeburn and SCS together wrote to the council setting out how they intended to respond to the issues raised in the abatement notices. So that's the green space area. In that letter, Braeburn confirmed that it would prepare and lodge a resource consent application to address the activities that could occur within the green space area across the whole site. And I just note that that extends beyond the area that's leased by SCS. Council responded via email on the 15 November 22, suggesting that the resource consent application should also cover the height issue. And just remembering, no abatement notice had been issued in respect to height, and Braeburn and SCS were maintaining that shipping containers aren't a building, so not required to comply with the height limits. Braeburn and SCS responded to the council on the proposed inclusion of the height issue in the resource consent application to deal with the abatement notices, stating that what they wanted to do was clean up the issues raised in the abatement notice, because there was obviously a live abatement notice sitting there, and they wanted to regulise that position by applying for resource consent in respect of those non-compliances. And they wanted to deal with that separately for the height issue, because there was no abatement notice issued alleging there was any breach of the height. They set out some suggestions, however, for a separate process which could resolve the height issue, and that could be either a declaration to the court or an application for certificate of compliance. So those were the two mechanisms that were being discussed on how to deal with, is a shipping container a building? And despite this, they did say that they were willing to discuss a potential resource consent application which went beyond dealing with the abatement notice issues, and on a without prejudice basis would deal with the height issue. So it wouldn't resolve whether a shipping container was a building or not, but it would deal with how high can you go on the site. And in good faith, they provided an undertaking on a without prejudice basis that SCS will not stack containers on the site within the building height limited area higher than 6 containers until we have the height issue resolved. So on 16 November 2022, the council, there's some correspondence, and it agreed with that proposed manner of dealing with the height issue, i.e. the resource consent application would deal with the non-compliances of abatement, and I'll come to what we included in the application in the minute. In particular, those height issues and the abatement notice issues were to be separated from the resource consent application, which was to address the issues raised in the abatement notice. Subsequently, and with hindsight, probably we made the wrong decision, Tim. Subsequently, Mr. Walsh for the applicant started to prepare a resource consent application to address the issues raised in the abatement notice. And then he at that stage had some discussions with council staff about whether it would be a better option for the resource consent to authorise buildings, so putting aside whether a shipping container is a building or not, on a without prejudice basis, generally above that 11-metre height limit in the district plan. So that would be a practical way of resolving the height issue without needing to engage on this as a shipping container a building or not. And Mr. Walsh had multiple discussions with council staff about this change in approach and the rationale for it. And it was understood that the council considered it was an acceptable way to address the height issue in a way that would avoid complex legal arguments about whether a shipping container is a building or not, with the inevitable risk of appeal. So against that understanding, and Mr. Walsh can answer questions on that, the application was lodged in December 2022. We then had a number of requests for further information from council on the application, and on the 11th of August, we received the council's Section 95 recommendation. This was a bit of a shock because it included a full description of the council's legal argument as to whether a container is a building and assess the effects of containers with respect to the proposed height limit, which was exactly what we had thought was not happening. This was contrary to the understanding that the applicant and SCS had reached with council staff, that the disagreement over the interpretation of the meaning building would not be debated during the resource consent process, and nowhere in the application was the increase in building height sought specifically in relation to containers. As I've said, that section 95 recommendation came as a shock to the applicant, and we didn't consider it consistent with the agreement that had reached with council as a process for resolving issues. The determination of the issue of whether a container is a building through this resource consent process was exactly the situation the parties were trying to avoid in the first place. In light of that section 95 report containing a recommended to publicly notify the resource consent application, the applicant considered that we had muddied the waters by, in good faith, including the authorisation of buildings above 11 metres, and had complicated which would otherwise have been a relatively straightforward resource consent application to resolve the abatement notice issues. Mr. Walsh was instructed by Mr. Peebles, on my advice, to place the application on hold, and we did so on the 14th of August 2023 while the applicant sought advice and considered what to do. Mr. Walsh advised the council on the 17th of August 2023 that the applicant will be amending the application in response to the section 95 recommendation, which dealt with the legal interpretation issue over buildings and shipping containers. So a revised application was lodged on the 22nd of September, which withdrew any reference to authorising buildings over an 11-metre height. The applicant also made it clear to the council that conditions to deal with noise were not appropriate or necessary, and this is bearing in mind the application is made by Braeburn as the landowner, and that position was taken on the basis that the leases require tenants to comply with district plan noise limits, and any issues around noise, and with apologies to Mr. Temperton, were to be addressed to SCS, not to the landowner, because that's not what the landowner was applying for. So then separately, in order to deal with the height issue that had been removed from the application, in order to make progress in moving that issue forward, and bearing in mind abatement notices have been issued in respect of the height issue at this stage, but in good faith we're seeking a resolution of that issue. In October and November, the applicant applied for a certificate of compliance in respect not only of stacking containers, but stacking anything actually on the site, hay bales and scrap metals, because Mr. Peebles, as landowner, is interested in what can be done on that site by any tenant, not just container company. And that application was heard by 2 independent commissioners, which included Commissioner Rogers. Independent commissioners issued the decision to decline the certificate of compliance on the 29th of January 2024 on the basis that stacked containers were buildings under the district plan definition. And then following that decision, the council did issue an abatement notice, a separate one in respect of height of the containers to both the applicant and SCS. So that's being done as a separate process. On the 19th of February, the applicant and SCS filed with the Environment Court notice of appeal on the certificate of compliance, notice of appeal on the abatement notices in relation to height, and an application for stay on the abatement notices. And on the 19th of March, the court granted that stay in respect of the abatement notices. On the 5th of May, the applicant and SCS filed an application for declarations in the court, simply asking the court to determine whether a shipping container, either alone or stacked, is a building under the district plan, and also whether the stacking of other items is also a building under the district plan. And we have a hearing set down to determine whether a shipping container or stacked shipping containers or stacked other items are a building on the 24th and 25th of September in front of the Environment Court, and all of the parties here are involved in that. So in the middle of the timeline, so between my paragraphs 22 and 22.2 and 22.4, so after the independent commissioners had issued their decision on whether a container was a building or not, but while the appeal period was still running, one of the 2 commissioners, Commissioner Rogers, issued his decision in respect of this application, which is now subject to the conditions being considered in the objection. And I just note that followed his decision in respect of the application for certificate of compliance, but it was during the appeal period. So there is a separate process running to determine that issue. Right, that's all fairly complex, and now I'm going to consider the conditions to which the applicant has objected to. Is there anything in that timeline that you've got a question about? Mr. Walsh is going to talk about it as well, but
No, not about the timeline. Just I am probably curious about the building definition issue. Not that it's determining the outcome of this, but just I guess just for my background. So the height limit in the industrial general zone limits buildings to 11 metres.
Only in the a particular area though of the
unit.
yeah, and you can point that out.
Yeah, that's fine. And in the green space area, is there a height limit?
No.
Buildings unanticipated.
Yeah, so there's no standard.
But Tim, you just might want to explain what we put in the application in relation.
Yeah, I'm happy to. We can come to that, but I'm just so. The issue that if they're determined to be buildings,
yes,
they're subject to 11 metres and consent to exceed it. If they're not buildings,
yes,
you can go as high as you want.
Yes, that's what
within practical.
Yeah, which is why we object to condition 22, which says shipping containers shall not be stacked beyond 22. Condition 22, 11, which came in. The commissioner put that in.
Yeah,
that wasn't in any of the books. So cutting to the chase on that, there's a height on buildings of 11 metres, and if the court determines that shipping containers stacked are a building, we're going to have to apply for a resource consent. If they're not a building, then we say that condition's ultra porous because you can't restrict us. So that's
I understand that. Okay, that's helpful. Thank you. So you also mentioned that there was an agreement of sorts. That you would stack containers no higher than 6. What does that equate to in terms of height?
Tell me what Aaron might be the best person to comment on that.
A maximum of 17.4 metres.
Okay.
So 15.6 to 17.4. Okay. Dependent on the type of container.
But just really simplistically, we were trying to clean up the abatement notice issues. So we're trying to get the resource consent that cleaned up the abatement notice issues, and we were trying to have a separate process that determined whether the shipping containers or other items stacked above are a building and caught by the rules or not. And we were really trying to deal with enforcement and get that all cleaned up and deal with the other issues separately. And unfortunately, they appeared. So 2 things appeared to have got tangled, which is the basis of the objection. One, the shipping container building issue seems to have unwittingly found its way back into this application, and that was added, to be fair to council officers, that was added by the commissioner when he wrote his decision. That wasn't dealt with in the officer's recommending report. And the other issue is the noise conditions, A, whether they're reasonable, but B, the whole issue of Braeburn is the landowner. They are the applicant. The Section 16 obligation relates to occupiers. And all along, Mr. Walsh has maintained if there are issues around noise, you need to go and talk to SCS. That's not the application that Braeburn as the landowner are making. So those are the 2 fundamental issues that are live here today, really, in simplistic terms. So, paragraph 25, the objection was lodged and related to a number of conditions. And to be fair, Mr. Walsh and council officers have worked together, and a number of these have been cleaned up effectively. So the applicant has worked through the majority of these and agreed them with council, but the ones that remain are land use condition 22, which was the one that appeared in the commissioner's decision, which says that shipping containers have to be limited to 11 metres high, and that's, we don't have resolution on whether they're a building or not. Land use consent conditions 8 to 20 relating to the management of noise on the site, and simplistically, Braeburn as the applicant says that's nothing to do with us, that's to do with the operator. And there's an issue around subdivision condition 4.2, but Mr. Walsh can deal to that. So, considering the height condition and noise condition, so just the basics on the power to impose conditions, obviously to be valid at law, condition must be for a resource management purpose, not an ulterior one. In particular, it must fairly and reasonably relate to the development authorised by the consent, which comes back to what was Braeburn applying for as landlord, and to which the condition is therefore attached. And then a catch-all of not to be so unreasonable that a reasonable planning authority could not have approved it. And there's some issues around information being taken into account in relation to visual assessments in particular that related to the application in the pre-amendment stage before Mr. Walsh amended it, and that visual assessment material coming in now to the objection argument. The courts in New Zealand have discussed many times the application of the Newbury principles to New Zealand resource management law, and the Supreme Court in Waitakere Council and Estate Homes held that the application of common law principles in the planning context requires conditions to be logically connected to the development. So that's A, what we were applying to be authorised, and B, it's got to relate to the owner of the land, not the occupier, not unrelated to it, and not relating to external or ulterior concerns. Since Estate Homes Section 108(1) has been amended to add some words subject to 108AA, and 108AA imposes additional restrictions on the discretion of a consent authority to impose conditions. And you'll be familiar with this, Commissioner, that the condition has to be directly connected to the adverse effect of the activity on the environment, which comes back to what is the activity for which we were seeking consent, because land itself doesn't create any noise. Section 108AA codifies the common law test in Newbury and Estate Homes, and in Linda's catchment group in Otago Regional Council. Andrew might want to mute himself. The Environment Court held that the section must be read as requiring a condition to be directly connected to the avoidance, remediation or mitigation of an actual potential adverse effect of the activity. So we've got to get to what is the activity on the environment. In this case, the court considered there to be little or no difference between the directly connected test and the logically connected principle in Estate Homes. We note that the Environment Court has previously held that the new Section 108AA provides a slight strengthening from the introduction of the phrase directly connected to, in place of the requirement for a logical connection, which was used by the Supreme Court. Right, so cracking into the height condition first. Condition 22, which I'm calling the Commissioner's condition, has the words any shipping containers and or buildings within the Portlink ODP 11 metre height overlay shall be limited to 11 metres from the sealed ground level of the site. Tim, I might just get you to interpolate here why there was any condition at all about the sealed ground level of the site. So the objection is to the words any shipping containers, but you just might want to explain the context of why that condition was seen as helpful, a condition like that, putting aside the reference to shipping containers.
Okay, so the sealed ground theory, the site that we're talking about is being raised by up to 1 metre, and so the height is measured from until the subdivision is completed. Height is measured from natural grounds, so a metre lower or up to 1 metre lower, and so it's a benefit to the until the subdivision is completed. That might take a little bit longer. There's a benefit to the applicant or to the consent holder to have it measured from sealed.
Yeah, so it's anticipating what the finished form is going to be.
Will be.
So we didn't have an objection to a condition that clarifies that issue. So we don't have an objection to a condition that says if you're measuring things, measure them from. But the Commissioner has conflated that with, I think, dealing with visual effects, and has added in the any shipping containers. So that's our objection. And there was no analysis of that in the section in the report. So
I suppose I have a question about that, and I just think wording he's gone for his shipping containers and all buildings. So
yeah,
was he trying to separate out whether the buildings or not? Or
we don't know. There's no analysis of it. It just popped in there. But I mean, we didn't have an objection to a condition that says when you're measuring stuff, this is how you measure it. Yeah. But this got turned into something else, and says got turned into something to deal with visual effects, which wasn't what the purpose of having a condition to get that clarity was about.
Yeah.
So I think we would be happy, Tim, if it says any buildings, putting aside whether a shipping container is a building or not, need to be measured from sea ground level. We didn't have an objection to that. What we do have an objection to is the word shipping containers being added in there without any analysis.
Yeah, and because it's tied up in the other processes.
Yes, yeah. So in light of the context of this consent application set out in the paragraphs above, it is entirely inappropriate this condition to be imposed. This condition was added by the Commissioner without any underlying analysis. But the Council's objection report now purports to, I suppose, justify the Commissioner's decision. And I say it's trying to backfill what the Commissioner decided by reference to a visual assessment. So if we look at the Council's objection report, they are referring to a visual assessment completed by the Council in 11 August 2023, but that visual assessment was done at a time before Mr. Walsh had amended the application to remove the height issue. And so effectively the reference now in this objection hearing to the Council now relying on that assessment involves asking the Commissioner to take into account information withdrawn from the application effectively on 22 September 2023 and really to artificially amend the application for them to jam, if you like, the height issue back in, which Mr. Walsh had removed. So the assessment information that related to that went as well. But none of this wasn't referred to in the Commissioner's reasoning for putting that condition in. This is referred to in the objection response that we have now. The Council's objection report notes that they consider the configuration of the container heights to form part of the resource consent application, and adverse effects were considered within that context. I can't see that in the section 95, but in any event, as we would say, the application had been amended. The decision maker intended the condition to provide clarity regarding what had been consented. Well, we want to make it clear that's not what we had applied for. So as set out above, in light of the agreement with Council over how the height issue was to be resolved separately, the application was amended to remove the proposed activity exceeding the 11-metre height limit for buildings generally, as it was clear that issue was an impasse between the Council and the applicant. In the interests of the site's occupier, and that the purpose of the application being to resolve the issues raised in the first abatement notice would be unduly tangled up with the height issue. The Council itself, in its own documentation, accepted that the revised application no longer sought to authorise buildings above 11 metres high on the site. In fact, the Council records this, as well as how the height issue was proposed to be dealt with separately through an application for a certificate of compliance, and a letter intended to update adjoining residents on 2 November 2023. This meant that all the supporting assessment information relating to that first application, relating to height, was no longer part of the application, nor was it able to be considered by the decision maker, and I would say nor is it able to be considered now. Taking into account that information would be an unlawful consideration of irrelevant material. We reject the Council's position set out in paragraph 35 that the consent application talked about the configuration of container heights. The applicant never proposed, and the applicant's the landowner, the applicant has never proposed any particular configuration of containers on the site as part of its application. Bearing in mind, Braeburn's trying to authorise a range of activities. SCS has indicated that it arranges its containers on the site in a particular manner to reduce noise effects. That's not about visual effects, and that's a separate issue, and it didn't form part of the application. Further, the condition does not provide clarity regarding what has been consented, i.e. what the activity is that is applied for, as the application quite simply didn't seek consent for that. The decision maker appears to have quite clearly misunderstood what was being applied for. Again, we note, and it is really important, that the application is made by Braeburn and not the tenant of the part of the site which is undertaking the shipping container activity. As you'll hear from Mr. Peebles shortly, SCS may not always be the lessee of the site, and the consent needs to be capable of applying to the site more generally without being tied to the specific activities of a particular lessee at a particular point in time. The condition on height falls outside the scope of the application in terms of what was applied for and assessed, as it is not a condition that is directly connected to an adverse effect of the activity which was being applied for on the environment. The condition goes well beyond the permissible connection between what was in the application and the conditions of consent proposed. The conditions are not linked to avoiding, remedying or mitigating the effects of the activity which was sought, which was about cleaning up the non-compliances in the green space area. The application did not seek to authorise any activity which would warrant such condition to manage effects on the environment. All the activities in the application were doing was effectively relating to enabling works on the site, except the use of the sealed area within the ODP green space area for activities permitted in the industrial general zone. So we say that in this respect, if we look at the connection between what was being applied for and what could be imposed by way of condition, height limits could only be imposed in relation to the activities sought to be authorised in that green space area. And as Mr. Walsh told you a minute ago, we note that condition 21, which is not objected to, does this. It limits buildings and shipping containers, so it doesn't matter whether they are one or not, to a height of 5.8 metres in the green space. So we say that's a directly connected condition connected to what was applied for, and that one's legitimate. We note that the Brookfield's opinion on this issue asserts that there is a direct connection between the Commissioner, I call it the Commissioner's Condition 22, and the effects of the proposed activity, but doesn't elaborate as to their reasoning on this, nor does the opinion engage at all on what the activities were that were being applied for in the application. And we're agreed with Council in terms of what the scope of the activities were that were being included in the application. In fairness, having read the Brookfields report, it may be that they were not aware of why the application had been revised to remove the proposed activity exceeding the 11 metres height limit for buildings generally. They may not have been all over that because it is quite detailed and context specific. We further note that the condition was not included in the Council Officer's own notification and decision recommendation. It appears to be inserted by the Commissioner. It first appears in the decision, which we note was made by the same independent Commissioner, or one of them, who had heard and determined the Certificate of Compliance application just a few weeks prior. It was still in the appeal period, on the issue of whether container is a building under the district plan definition. One interpretation of this late insertion by the Commissioner, sorry, it should be Commissioner, is an attempt by him to limit shipping containers to a building height of 11 metres in light of his view in the decision on the Certificate of Compliance that a shipping container is a building, and that effectively undermines our legitimate right of appeal on that decision. Noting that while an appeal on the COC decision had not been made at that time, he would have been aware of the appeal period was still running. We say that the insertion of condition 22 with its reference to shipping containers is inappropriate in the light of Newbury, particularly in the context of the height issue being separately subject to live court proceedings, and at the moment we've got a hearing which is imminent, which is in September. If the decision of the court on the declaration finds in favour of Brayburn's, their landlord's interpretation, the condition on the resource consent will be unreasonable, as shipping containers are not limited to 11 metres height under the district plan. If the decision on the declaration finds in favour of the council's interpretation, then shipping containers are a building, and the consent condition is actually unnecessary because the 11 metre height limit rules in the district plan apply anyway, so we would need to apply for resource consent. It is the outcome of that Environment Court hearing that will determine whether SCS requires resource consent to stack shipping containers in excess of 11 metres. As I say, if resource consent is required because they're a building, there will need to be a separate resource consent process, and it'll probably be SCS that makes that application. Where the effects of the height of the containers will be properly considered an appropriate condition, and will probably be considered and assessed, I have to say, because the assessment here, I don't know what assessment the Commissioner did, and appropriate conditions can be imposed at that point in time. It should be noted that if the reference to shipping containers remains in the conditions, we'll have to appeal this decision because of timing, because we won't even answer on the court's process until September or later. So we'll have to appeal on this decision while the court considers the interpretation of the building issue. That just delays the implementation of this resource consent, which was designed to clean up those abatement issues, notice issues, and also for the benefit of the residents. In the meantime, other conditions such as the acoustic fence aren't being implemented. So it really prevents cleaning up of those other issues, some of them for the benefit of the residents. So that's the end of the height issue. Is there anything in that that's unclear?
No, nothing's unclear. Just a question back in your paragraph 40. Coming back to the relationship between the applicant and the occupier. Presumably, and I'm talking about the applicant never proposed the configuration that SES does. So the issue is...
Can I explain how that happened? And it'll come when we come. So there was an issue, there's the issue about is the SES complying with the district plan limits. So SES commissioned a report themselves separately to effectively deal with a risk of enforcement, I suppose, to be able to satisfy the council that they were complying with the district plan limits. So there's information provided in that context that seems to have wound itself into this process about what SES are doing on site, how they're configuring their operations and what they're doing to make district plan limits. That somehow seems to have wielded its way into this consent application, which isn't actually the landlord's issue.
No, that was my question, I guess, is that the landlord as the owner gets a consent for the site.
Yes.
SES operate on the site, and presumably they have to independently anyway comply with any applicable.
Yes, and the lease says that. The lease says that you've got to comply with the district plan limit.
And be subject to enforcement action if they do something in breach of any of those documents.
Yes. Yeah. Yes. So what is really important is that the acoustic report that was prepared by Mr. Jackson and was peer reviewed by the council was prepared for SES and was provided by SES to council to give them some comfort the district plan limits were being complied with. It wasn't the application, if you like, it's SES explaining how they are conducting their operations in order to be able to comply with district plan limits. Is that simplistically, Tim?
Yeah, that's correct.
That's okay. So that wasn't the application, if you like. It's the council saying we're not comfortable as to whether your current operator can make district plan limits or not. So SES supplies some information saying we are. And this is how we operate to ensure we are. But that's not Brayburn's application.
No, and hence the argument around if they don't comply, it's a Section 16 issue and other enforcement issues.
Or if they're not complying, Mr. Templeton has said we'll go and get our own resource consent. But that's nothing to do with Mr. Walsh's application. Yeah. Sorry. Right, so we're on to noise now. The objection opposes all of the noise conditions imposed by the decision. And just if I can make the general statement, this is about if there needs to be conditions imposed on noise, they need to be imposed on a resource consent relating to SES. SES will say we don't need one because we can demonstrate they were applying with the permitted rules in the district plan, but firstly, we note that the application did not seek to authorise any activities that would require resource consent for breaching the district plan noise limits. The revised application was specifically limited to site enabling works and general activities permitted in that green space area. Nevertheless, it is accepted that as the application is for a discretionary activity, the council may consider noise effects arising from the activities proposed, but that's the activities that are proposed in the application, not what SES are doing on site. As above, the Resource Management Act requires that conditions imposed on a resource consent must be directly connected to the adverse effect of the activity on the environment. The activities are effectively for enabling works on the site, except the use of the sealed area within the ODP green space for activities permitted in the industrial general zone. So in that respect, conditions to limit noise could only be imposed in relation to that area. That, with reference to the Newbury principles, currently the noise conditions are not reasonable and do not fairly relate to the development authorised by the consent. Throughout the entire processing of this application, the council has raised concerns regarding the noise effect of SCS's container depot. This is despite the applicant's often stated position that this is not a relevant consideration. SCS is not the applicant, and the resource consent is sought to be more general, so it could apply to any industrial operator that Mr. Peebles might choose to lease the land to. Nevertheless, in order to allay council's concerns and to avoid the risk of another abatement notice, SCS did provide the council with reports it had commissioned from Powell Fenwick, which demonstrated that SCS's activities could comply with the district plan noise limits. This conclusion has since been confirmed in a further assessment by Powell Fenwick dated 27 June 2024, which you're going to hear about shortly, where Mr. Jackson's going to confirm that the container yard is currently operating in a manner that is compliant with the district plan noise limits. We emphasise that these assessments are not considered necessary in the context of this application, relating more generally to the entire site and not just SCS's activities. And that was an action taken by SCS and a responsible action. We do note that in the original Section 95 recommendation to publicly notify, and that's before the height limit was taken out, the council commissioned AES to provide a review of Powell Fenwick's noise assessment. And we note that that review acknowledges that Powell Fenwick's assessment only relates to one of the tenants on the site, i.e. SCS, and that other tenants of the site may contribute to cumulative noise levels. It considers that the daytime district plan noise limits provide a typical level of protection for residential amenity for general environmental sources and appears broadly consistent with existing ambient noise levels in the area. It considers that the daytime district plan noise limits are typical of residential zone protection and suitable to ensure sleep protection. It raises the issue of special audible characteristics from container handling and considers such noises are likely to cause adverse community response at lower levels than other types of noise. Therefore, they consider that such noise should be penalised by 5 dBA under NZS 6802. And they said that provided the noise levels from the container handling, including that special audible characteristics penalty, complies with district plan noise limits, the noise would be at a reasonable threshold. And considers that it appears likely with the description of activities in the Powell Fenwick report, and that is SCS's current activities, that noise levels from the container handling activity can comply with both the district plan noise limits and AES's proposed threshold for reasonable noise. And I just note, and we'll come to this later, that we do not consider the comments made in paragraph 20 of the council's objection report to accurately reflect what AES said in their report. At the time the noise conditions were proposed by the council, the applicant through Mr. Walsh made it very clear that the noise conditions were neither appropriate or necessary. Not that Mr. Walsh would use these words, but in legal speak, the conditions fail the Newbury principles and the requirements of Section 108 AA. Since the decision, the council has advised by way of a community health update sent to subscribers that its environmental health team has carried out further monitoring of the site to ascertain compliance with district plan noise standards. The community update records that officers visited the site on the 9th of April and took noise measurements while operations were taking place. Their levels taken were below the district plan noise standards, confirming once again that SCS's operations are compliant and the noise conditions imposed are not reasonable, appropriate or necessary. And just by way of explanation, the acoustic fence is not there yet. So they are complying without the acoustic fence that is proposed. We note that the results of council's noise monitoring for the site has not formed any part of the council's assessment for this application and has not been information made available. I don't think it was made available to Commissioner Rogers, and as far as I'm aware, sir, it hasn't been made available to you. So we wish to ensure that that information gets in front of you, but we've got some question marks about why that information hasn't been provided to you. Section 16 and the duty to avoid unreasonable noise. So we have, Mr. Jackson's going to tell you today that the district plan noise limits are appropriate. AES said that in their review as well. And despite council's own review by AES as set out above, we understand that the basis for the council's objection, response to the objection here today, and in particular their support of condition 8, which imposes stricter noise limits than permitted in the plan, is that we have this other duty under section 16, which might require an operator to go further than what the district plan rules require. However, bearing in mind that this is an application by Braeburn as the landowner, section 16 of the Act imposes a standalone duty on all occupiers of land to adopt the best practical option to ensure that the emission of noise from the land does not exceed a reasonable level. This is important as the applicant is the owner of the land, not the occupier, and the section 16 obligation falls on SCS as the occupier. Now, while we don't generally disagree with Brookfield's opinion, its general commentary on section 16, we would add the following in the context of this application. Whether noise is reasonable or not, whether you need something beyond the district plan limits, is a question of fact and degree in the specific circumstances. And I don't know whether Brookfield's were aware of the AES review, which makes its conclusions that the district plan limits are reasonable. It is not necessarily tied to district plan standards or to a certain decibel noise level, although they are relevant factors. And that's why I make the point. I'm not sure whether Mr. Green was aware that AES had reviewed the district plan limits and determined that they were reasonable for dealing with amenity. The court has considered that noise that disturbs people's sleep and also disturbs the reasonable use and enjoyment of their property during the day can be categorised as unreasonable, unless the recipients are hypersensitive, and even then the noise may still be unreasonable. We agree with the Brookfield opinion that the obligation under section 16 applies to the occupier and not the owner. However, we do not agree with the reasoning then adopted by Brookfield, and in fact I don't understand it, that somehow in this case that the applicant as the landowner is obliged to comply with section 16. Our reasoning is occupier is defined in the Act as meaning the inhabitant occupier of the property, and for the purposes of section 16 includes any agent, employee or other person acting or apparently acting in the general management or control of the land. And Mr. Templeton will certainly tell you that Mr. Peebles is none of those things in respect of his operation of a container operation. A landowner or lessor is not a person who is acting in general management or control of the land, and Mr. Peebles doesn't purport to be. It has given away those rights by granting a lease to SCS in this case. In the case referred to by Brookfields, which was it was an airport case at the bottom of footnote 23, Sound Incorporated versus Whangarei District Council, just actually did involve exactly that. It was the council was the landlord, and then there was a helicopter operator that was creating noise. And the court said that the section 16 obligation related to the tenant, not to the landlord. And in fact, in that case, the lease had exactly the same conditions as the lease has here, where all that Mr. Templeton is required to do is to meet the district plan limits or comply with the district plan or get a resource consent. This is understandable as no noise emanates from Mr. Peebles owning the land. Further, in a lease arrangement, he has given away his control over the activities undertaken on the site by SCS, which has exclusive occupation rights. Here, the landowner has no ability to control the activities of SCS, and it's not the regulator, so nor should it be required to do so. Further, if Brookfield are correct that a landowner is also an occupier, where the actual occupier is relying on rights somehow afforded by a landowner's resource consent, then I can't see any point in section 16 referring only to occupiers. and having a definition that effectively excludes landowners from the Section 16 requirements. In any case, though, you're going to hear from Mr. Jackson shortly, who concludes that, similarly to AES, that the noise limits in the district plan are consistent with and in some cases more stringent than the noise limits set in the WHO guidelines and in NZS 6802. The noise limits in the district plan are appropriate and reasonable for addressing health and amenity matters as they align with that applicable guidance criteria. And conducting industrial activities on the sealed area of the ODP green space does not increase adverse effects due to noise, nor does it result in an unreasonable noise level, provided those district plan noise limits are adhered to. Further, as noted above, AES and its peer review of the SCS report for the council consider that noise levels from the container handling activity can comply with the district plan noise limits and AES's own proposed threshold for reasonable noise. As such, it's not necessary to impose conditions on the basis that the noise from SCS's operations is complying with a reasonable noise threshold. The application isn't seeking to authorise specific activities relating to SCS, and should there be any non-compliance by SCS with either the district plan or Section 16 duty in the future, which applies only to occupiers, the council has separate mechanisms available to them to resolve this. They don't need to do that through conditions on a consent held by a landowner. Further, we note that Section 16 places an emphasis on the use of the best practicable option. To this extent, we note that part of the site is currently leased, part of the site currently leased to SCS may be leased to another lessee in future who might not even use the site for a container depot. As such, imposing specific conditions based on the current use of the site is not appropriate. There may be other ways in which future lessees may employ the best practicable option for their activity to comply with their own obligations under the district plan and under Section 16. I'm nearly there. The noise conditions are considered unfair and unreasonable in the context of practical operational requirements for the site and financial implications for the applicant. The evidence from Mr. Peebles sets out that the estimated cost of establishing the container wall is likely to be in the region of 2.7 million. And based on advice he's received from Bailey's, the conditions at the moment would significantly impact on the rentability and saleability of the land, such that the applicant will need to offer a rental discount of 20% to account for the impracticality of those conditions and consequent restrictions on operations efficiency. That would result in an estimated loss in annual rent of about 300,000 per annum. The market value of the land will be reduced by at least 20%, which would equate to approximately 6 million reduction in value. The evidence of Mr. Temperton sets out the significant practical implications for SCS's own operations on the site, including in particular the limits on operating at night, the limits on how often the noise barrier can be moved, given that this is a container park and the containers move around constantly, and the limit on the number of hoists that can operate at any one time. So we say it is neither reasonable nor appropriate to oppose height conditions or noise conditions to this consent. Those conditions fail to meet the Newbury tests and are not valid at law.
Thank you.
That's it from me.
Really helpful. Thank you. There is a question, but I haven't quite figured out.
You can do it at any stage.
I'll come back to that.
At any stage.
It's probably more just clarifying the lay of the land between the relationship between applicant and
tenant.
tenant.
Tenant, yes.
Thank you.
And actually that airport case, I might give you a copy of that. That was the distinction between council as the landlord and I mean, it's pretty simple. It just says Section 16 refers to occupier. In this case, the council's the landlord. The helicopter operator is the tenant. They've got a lease that says comply with all the law. That's all the landlord's required to do.
Yeah. So what? These are probably reasonably simplistic questions. But what you're saying effectively is that Mr. Peebles can have whatever consents he likes on his site. Anyone who comes and leases land off him has to comply with
The
relevant
district
district
plan
plan in any event.
and the RMA in terms of section 16.
Yeah, and if there's conditions of the consent, then they will be transferred to the lease if Mr. Beevils wanted them to be relevant.
Yeah, but
So
he may not.
may or may not.
He may not. Yeah.
So the consents are related to the operation and layout of the entire property. So establishing effectively the envelope that different things can operate within.
Yeah.
Tenants have to get their own consent.
Yep.
Yeah.
That's fair enough, is it?
And it's in the lease.
And it's in the lease anyway. So I guess you'll be saying to the court in some respects that the fact that there is an existing occupier on the site has, let's use your words, tangled the issues.
Yes.
Yes.
Yeah. And I think Mr. Walsh makes that point. Mr. Peoples made the application without any activities on the site. We wouldn't have been looking at noise. We wouldn't have been looking at height. It would have just been, with permitting some activities in that green space area, dealing with the abatement notices. It's really what's tangled is the fact that SCS is on the site and the neighbours don't like it. That's
No, thank you. That's
No, I thought you weren't reading it off the screen. I always get nervous when witnesses read off their screen because they never really have a different version.
Okay, my name is Richard Peebles. I'm a director and shareholder of Braeburn Property Limited, which owns a site to which resource consent relates. We have objected to a number of the conditions imposed by the decision. Economic implications. The site is currently leased to several tenants, including centralised container services. SES currently operates the container shipping depot on the part of the site. Many of the conditions which have been objected to relate specifically to the current activities of SCS on part of the site. However, that part of the site may not always be used for this purpose. At some point in the future, Braeburn as lessor or SE as a lessee may decide to terminate the lease. It is possible future lessee will use the site for an entirely different purpose, meaning the site will not necessarily always be a container yard. The application for resource consent was deliberately drafted in relation to industrial activities generally, so it could apply generally to the site and any industrial activity a lessee might want to undertake, without the need for Braeburn to get new resource consents every time there is a new lessee. I have some serious concerns about the conditions in the objection from a commercial perspective. My estimate of the number of containers required in regards to the container barrier is one of the conditions, which would be 4 high in the northern portion of the site, is 267 containers at a market value, and this is on the assumption that if SES container wall will have to remain, at the market value of 10,000 per container, that equates to 2.67 million, plus obviously the cost of placing the containers. It's likely the cost for this condition alone could be in the region of 2.7 million. I did not apply for consent for a transitionary container park, yet the conditions suggested relate specifically to a container park. I'm a long-term owner investor, and it is likely that numerous tenants will occupy the site in the future. Indeed, given the stringent and flexible nature of the conditions imposed, with particular regard to the container wall restrictions on movements, which are limited to 5 per year, and limits on hoist numbers of 2 hours of operation, there is a possibility in the site not being suitable for a container park. In this situation, I would be attempting to secure a tenant with onerous, unworkable conditions, which with most other uses could make the site unleasable, with particular regard to the cost of the container wall. The restriction on the number of hoists is puzzling, particularly if the hoists are electric, or indeed an alternative type of tenant, such as a garden nursery, has small hoists with forklifts. Currently, there are more than 2 hoists operating, and the operation in regards to noise complies with district plan noise limits. In regards to restriction on hours, there are many activities that can be done on site that create little noise, such as cleaning containers for the current activity. And whilst the current tenant may be prepared to accept that condition, it could well be disqualifying for other tenants. I've sought advice from my advisors at Bailey's Commercial Real Estate, specifically regarding the impact of the proposed conditions on the rentability and rental rate for future uses of the site, and also the value of the land. These issues are addressed below and the advice is attached. Rentability and rental rate. The conditions imposed by the council, or the commissioner, would significantly hinder Braeburn's ability to lease a site in the future. In particularly, the conditions that impose limits on the usage of machinery would reduce operational efficiency for potential tenants. This is a critical consideration for industrial operations. And conditions 10 and 11, which require the construction of a noise barrier, involve significant costs and require specialised knowledge which potential tenants may lack. There is also safety concerns associated with these requirements, particularly for future tenants whose primary business does not involve containers. Containers stacked in a single file would need to be pinned down and weighted, especially during high winds. Just to elaborate, when they stack containers, they stagger them so the wind effect is not just on a one high wall. So just a four stack of containers, you couldn't just stack them and leave them there from a health and safety perspective. So Aaron, sorry, the current, I didn't mean to become an expert in containers.
That's all right.
That's all right.
You're becoming one.
Yeah. Sorry, the current and future tenants are required by the terms of our leases to comply with the provisions of all statute, ordinances, regulations and bylaws, including district and noise standards. The advice I received from Bailey suggests that industrial tenants are aware and accept that they will operate their businesses within the noise limits set out in the district plan. However, in Bailey's experience, industrial tenants are often not willing to operate within specified noise restrictions imposed as conditions of consent, as they are not willing to accept extra costs of monitoring and risks of enforcement. To compensate for the impractical conditions and consequent restrictions of operational efficiency, Bailey's has advised that it is likely Braeburn would need to offer a rental discount of at least 20%. However, even with the above discount, it is likely tenants would opt out and go to other, perhaps even less preferable locations that do not have rigorous constraints. And I want to highlight that, securing tenants, that's what our whole business is about. And anything you put in that makes it less likely to get a tenant or more difficult, it's not just a loss in rent, it's the time taken to try and achieve a tenant. However, even with the above discount, it is likely tenants would opt out and go to other, in such circumstances, attracting tenants will likely prove challenging and will potentially lead to prolonged vacancy periods at the site. This would have very serious financial and commercial implications for Braeburn, given the size of the site impacted by these conditions, and I've only assumed the last 2 yards closer to the resident with 5 hectares, the total site's 10 hectares. The approximately 5 hectares loss in annual rental at 20% would equate to 300 per annum, plus the loss attributed to the extra time taken to lease the site. Value of the land. Bailey's have also advised barriers to leasing, such as overly restrictive noise conditions, increasing investment risk for potential investors, when valuing property based on potential rental income, a 20% discounted rental rate. The property value would also be reduced by at least 20%. And we highlight at least because an investor may look at it as on a worst case scenario. The value of the property therefore likely be diminished as a consequence of the decreased rentability and discounts to rental rate. The conditions would also limit the ability of future owners and or tenants to redevelop the site. Even with discount for reduction in rental rate, potential buyers may be deterred by the conditions, further limiting interest. Overall, the conditions are likely to have significant impact on the overall market value of the property. Based on the above estimate of 300,000 per annum, would equate to a loss in value of approximately 6 million, which is based on a 5% yield for ground leases is legal. The loss is directly related to these owners' conditions for a particular activity for which they did not apply for. We're talking massive financial impact. Compliance with district plan noise limits. The council officer's report states in the report, without evidence stating otherwise, compliance may or may not be able to achieve. However, I am aware that the council has undertaken extensive noise monitoring on the site since August 2022. I've been sent information from a third party on details of noise monitoring that the council has undertaken for the site. This is attached as Appendix 2 to Appendix 2. To date, I'm aware approximately 54 tests. So we know there's been 19 days of tests and they do 3 to 4 per day. So that's not an exact number, but it's an estimate. 54 tests have been undertaken, and yet the outcome of these tests have not been referred to or even acknowledged in the council's report. Of the approximately 54 tests, I'm aware of only one minor non-compliance recorded on 24th March 2024. In response to the non-compliance, I understand the hoists were depowered and insulation was installed in the engine bays to dampen the noise. Since this, as far as I'm aware, no non-compliance with district plan noise standards have been recorded. Based on the above, 53 of the noise monitoring tests show compliance with the noise mitigation measures. 53 of the noise monitoring tests show compliance without the noise mitigation measures proposed. So in other words, there is no container wall 4 high along the northern boundary, and that's not limited to 2 hoists, and there is also no acoustic fence. So of the 54 tests done by council, 53 show compliance without the mitigation proposed. It is difficult to see how this amount of testing would not be considered ample evidence that compliance is being achieved. I'm very concerned that despite the council report officers having access and knowledge of these tests, they have not considered them as evidence of compliance. They've also not provided these to me, despite noise being a very relevant and contentious issue to me or Mr. Hamilton, contentious issue in this consent process, and possibly more concerning have not provided this evidence to the decision maker. I would suggest that it is reasonable to assume that council has purposely withheld this information. And I'm saying it's reasonable to assume, I'm not saying that is the case, despite its obvious relevancy, and suggests it clearly supports our position that compliance with noise standards is being achieved. In addition to the council's own monitoring, a report has also been prepared by Powell Fenwick, which included modelling for noise assessment. Powell Fenwick has also recently undertaken real-world testing, which is in a memorandum dated 27th June, attached to Mr. Walsh's evidence. Testing occurred over 4 days and consisted of 10 separate tests. Overall, the site was found to be compliant, apart from an issue with the generator, which has since been remedied by an operational change. The outcome of Powell Fenwick's real-world testing further shows that compliance with district plan noise limits has been achieved without the noise mitigation measures of the container wall, the limiting of hoists, and the acoustic fence. The imposing of the suggested activity-specific noise conditions for an activity for which I have not sought a resource consent for will have enormous financial and operational impacts on me as owner and the tenant as operator. This is despite ample evidence that the conditions are not required as the activity complies with the district plan noise limits. I further cannot understand the conditions relating to limiting containers to 11 metres, given we have not made an application for container park activity. There are no conditions relating to restricting height to other outdoor storage products. I purchased the site and carefully reviewed the district plan, sought town planning advice, confirmed it was zoned correctly as industrial and industrial uses, including outdoor storage, were and are a permitted activity. I spent approximately $12 million on creating an outdoor storage facility, marketed for lease and secured numerous yard-based tenants. We worked closely with council. So when we actually filled the site and set the boundary, we had weekly meetings with council. I can remember being on site and actually putting stakes in the ground where the yard was going to be sealed, where the fence was going to go, where the bund was going to go. The council at that time said that a 20-metre landscape strip was all they required due to cost of maintaining. The position of the yard, the fence, the earth bund, the proposed piece of fence. We worked with senior council officers who advised our consultants that a 20-metre landscape strip was all they required due to the ongoing maintenance costs, consistent with the balance of the Port Link development. And that's very important in that, I don't want people would have assumed that we've gone ahead and did this work. We liaise weekly with council staff. you know, in regards to the ODP green space, the ODP green space is an A4 plan in the district plan, and no one, to this day, no one can tell me where the actual boundary of that ODP space is. You know, it's the black lines determining the boundary of the ODP on the A4 plan is 3 to 4 metres. That's the black line, let alone the colour of the green space. So we've applied for a consent for using an ODP green space where no one can tell me where the actual boundary is. It is a ludicrous situation that as an owner, that, you know, the council are maintaining it's measured from a boundary of so many metres, but they can't tell me, but it's clearly not from the boundary because the green space shape follows the bank of the river. You know, clearly as a council's position is incorrect, but we do not know where that boundary is. And that is unreasonable for a property owner to be required to apply for consent to use an area where no one can even determine what the non-compliance areas are. Now, I've been battling about finding out where this position was, and I've been assured we should just apply for a consent without going down that route. But, you know, the option to withdraw from the ODP green space isn't there because we don't know where the boundary is. So that's just frustration getting the best of me. Establishing this facility close to the local port, and this is a very, very vital, because a lot of the containers previously have gone out to Rolleston. So establishing this facility close to the port, the environmental positives and the huge reductions in mile travel by road by container trucks, which has previously been operating from Rolleston. So, you know, if we actually make it so difficult that a container facility cannot actually operate from this facility, it will have massive financial and environmental effects. Conditions that make the operation unworkable or overly restricted will have huge financial and environmental perspectives. Thank you.
Thank you. I don't have any questions. That was quite very helpful from the owners. So if it does pop up on that, I should have given the duration so I can yes, but that's really useful. Thank you.
I've got Mr. Temperton next. Do you want to crack on with that, or were you wanting a cup of coffee at some stage?
I'm okay. It depends on how
that's fine.
Maybe we do Templeton and
then we can have a break.
Yeah. Sorry, I didn't realise that was people, so that's all right. Thank you for your statement. You've got the the noise monitoring by public. Yes. So is that document a Portland? Is that a council report, or is that just a?
So you took out the PEL, you took out our own one, or
this is an appendix 2 to Mr. Peebles.
Yeah.
So
yeah.
Sorry.
So no, this is the information that.
Somebody provided by council's monitoring.
No, we haven't had it from the council. Mr. People's got it from a third party, okay. So we have not been provided. Yeah.
I was forwarded that list, and together with a lot of emails from someone who's been dealing with the enforcement officer. Okay. So we were a bit shocked to find out that there've been 19 days of testing over the last 2 years, 54 tests, and we weren't aware of them. We weren't aware of the results, yet, you know, we were told that there was no evidence that the site complied.
Yeah, so we have not been provided with this information, and we assume nor have you by Mr. Jordan's.
I think it's one.
So we have got, there is a whole series of emails which we decided not to attach. Sure, we thought you should get the information direct from council.
Yeah, I mean, you can ask for it from council directly.
Good morning, my name is Aaron Temperton. Ko Ngāti Roanui Toko Iwi. I'm employed by Cube as the National Health and Safety and Environment Manager for the company. Cube is a shareholder of a number of companies, including Specialised Container Services Christchurch, SCS, which operates a shipping container depot facility at 320A Cumnor Terrace, Woolston, Christchurch, referred to as the site. As part of my role, I've been responsible for progressing consenting and compliance-related matters for our container depot located at Woolston. Prior to my role at Cube, I spent 17 years with KiwiRail and its predecessor entities in a variety of roles ranging from commercial to operations to health, safety and compliance. This statement is provided in support of Braeburn Property Limited's application for resource consent to authorise works at the site, including a boundary adjustment subdivision, hard stand and fencing, use of land, earthworks, and industrial activities within a landscape and stormwater area, and its subsequent objection. I am authorised to provide this statement on behalf of SCS. In this statement, I will cover the following: SCS's operations, alleged noise complaints, noise monitoring, noise minimisation, and SCS's concerns with the proposed conditions. Regarding SCS's operations, SCS operates a shipping container depot facility at 320A Cumnor Terrace, Woolston, Christchurch. SCS is the subleaser of these premises, leasing half the premises from Braeburn and half from New Zealand Express. Braeburn is a registered owner of the site. SCS has been operating a shipping container depot at the site since July 2022. Initially, SCS began operating from the eastern half of the site, and since approximately April or May of 2023, has also been operating from the western half of the site. SCS's operations at the site include the receipt and temporary storage of empty shipping containers in transit between the port and either the origin or destination point for the container. At the site, the shipping containers are also assessed and repairs are undertaken if required. The shipping containers are then temporarily stored on the site until the next consignment requires them. The containers are moved around the site using specialist material handling equipment, being hoists. The hours of operation at the site are from 7 a.m. to 5 p.m. SCS currently does not operate from the site at night. As the tenant at the site, SCS acknowledges that it is responsible for the ongoing compliance with noise requirements. SCS operates within the district plan limits. If SCS believed it was operating outside of these limits, it would have remedied this and/or applied for a resource consent. Regarding the complaints, at paragraph 20 of the objection report, the council states, over time, council has received numerous complaints over noise for the activity proposed, and complaints have been raised which suggest the current operation without mitigation is not acceptable and therefore residential amenity is not maintained. I wish to respond to this. My role as National Health, Safety and Environment Manager at SCS is well known to the council, and I have been the primary contact for any complaints related to this site. While I have not attended any of the community meetings, earlier this year, on the 21st of March, I did watch a community meeting which was live streamed. During this live stream, there were a number of residents who were voicing concerns about noise from the site during the night. I was surprised that there were complaints about noise at night from the site, as SCS does not operate during nighttime hours. I'm not sure how appropriate it is for me to go off script in this area.
You can go.
Rachel, you may recall, being there, how vociferous some of the residents were around nighttime issues, and a couple of statements that were made of us waking people up at 2 o'clock in the morning.
And you don't operate at night.
It's Sunset East side with RMA a few times.
Yeah. Thank you. I can confirm that there are no programmed operations that are carried out at night. There have been rare occasions, 2 that I can recall, when workers have started our hoists prior to 7 a.m. Just in the further interests of Richard's education as a container park specialist. So these are large machines. So when we commence for the day, we start them up, do pre-start checks. So it's not a matter of turn it on, off you go kind of stuff. And we have had and acknowledge there have been a couple of occasions where overzealous workers have turned the machines on prior to 0700 hours. It has been made explicitly clear to workers that hoists are not to be started until after 7 a.m. Our local managers on site provide regular verification that the hoists are not operational prior to 7 a.m. An example of that is annexed and marked AT1. Periodically, this detail has been provided to council. Outside of the events detailed above, I am extremely confident that any complaints associated with nighttime noise cannot be attributed to us and our operations. I've had very few instances where the council has contacted me directly to inform me of or discuss any complaints. I would expect that where the council considered these serious, SCS would have been contacted for comment as part of any investigation. From the fact that I have not been regularly contacted, I've inferred that the complaints were not considered serious. Apart from the complaints I have referred to in this statement, I do not recall receiving any advice from the council regarding complaints. Noise monitoring. I am aware that the council has recently carried out noise testing around the site. On 9 April 2024, I received a community update from the council, which included a section related to noise monitoring. The community update advises that the testing did not detect any non-compliances. Specifically, it stated, officers visited the site on the 9th April and took noise measurements while operations were taking place. The levels taken were below the district plan noise standards. Officers planned further visits to take measurements and determine compliance. Annexed to my statement and marked AT2 is a copy of that update. On or about 22 May of this year, Mr. Craig Jorgensen, Team Leader, RMA Monitoring Compliance of the Council, informed me in a phone call that Council has been undertaking noise testing on the site and have not recorded any noise exceedances. I have not been provided with copies of the testing results, nor has SCS Cube been advised of any non-compliances with the district plan noise limits or a breach of Section 16 of the Resource Management Act. As a result of the testing carried out by the council. The conclusion reported in the community update and the results of the council's testing aligns with the testing carried out by Powell Fenwick. The assessments by Powell Fenwick were originally undertaken when the application was being prepared to determine that SCS could comply with the district plan noise limits. Most recently, in its assessment dated 27 June 2024, Powell Fenwick have confirmed SCS is operating in compliance with the district plan limits. SCS is mindful that it operates an industrial activity adjacent to a residential area. We have responsibly taken steps to ensure that noise emissions from the site are reduced. These include, recently we have purchased 2 later model upgraded hoists. I'll touch on those a little bit later on. We have undertaken ground repairs specifically to limit noise outputs. We have physically isolated a generator. We've previously installed soundproofing insulation on the hoist and previously reduced the power outputs on the hoist to reduce noise outputs. Regarding the upgraded hoists, recently 2 additional hoists were purchased to replace 2 of the existing hoists currently at the site. These are later model Kalmar empty container handlers. These machines are currently being assembled on site pending deployment into service. We expect that these will be in service in August of this year. It is my expectation that these machines will be noticeably quieter than their predecessors. This is primarily attributed to the following, and this information has been provided to me by our in-house engineering services people. The new machines are fitted with more modern silencers. They have a fiberglass engine casing, as against the existing units have steel casings. They are equipped with wear pads between the inner and outer channel on the masts, whereas the existing machines were steel on steel. This will produce less of a rattle effect as the machines travel around the site. On the 15th of July, I sent an email to the council advising of this, and it's annexed and marked AT3. Bridge repairs. On 26 March 2024, Ms. Yvonne McDonald from council visited the site. She advised that she was there to assess an area of the site, being a concrete bridge over a culvert, that was considered to be creating undue noise. Prior to Ms. McDonald's visit, we had already identified that aspects of the seal on the relatively newly constructed bridge straddling the culvert was failing, and the uneven surface on the bridge created a bounce when machinery moved across it. When this bounce occurred, there was an audible rattle which could be heard. To reduce the rattling sound, SCS have carried out a temporary repair on the bridge, which has reduced the rattle significantly. Below is a photograph which shows that repair. Once we are able to access the full site, a more permanent repair will be carried out. I advised the council of this on 22 May 2024, marked as AT4. Isolation of generator. Recent noise monitoring carried out by Powell Fenwick identified that the site was complying with the district plan, with the exception of on one day. On this day, refrigerated containers were being pre-tripped, which required the use of a generator. Essentially, that's the requirement for refrigerated containers to be operating. This caused the failure to comply with the noise standards when measured from the residential boundary. Powell Fenwick made a number of proposed mitigations to ensure compliance with the district plan. This was contained in a memorandum from Powell Fenwick dated 12 June, which I understand Mr. Walsh will be producing. In response to the non-compliant, and as per advice from Powell Fenwick, SCS has established a semi-permanent container barrier to shield noise emissions from the residential zone. This measure resolved the non-compliance as reported in the Powell Fenwick memo of 27 June 2024. Once the objection is resolved, the site will be able to be optimally configured and the generator will no longer be required. Our concerns regarding the proposed conditions. The noise management conditions that have been proposed by the council are specific to SCS's operations on the site. Mr. Walsh and Mr. Peebles have set out in their evidence why they consider these conditions are not appropriate to impose in the context of future industrial activities being undertaken on the site. From SCS's perspective, the conditions have significant practical implications for the operation of the site. These are a limit on activities during nighttime hours, a limit on altering the required noise barrier 5 times per year, and a maximum of 2 hoists to operate at any one time. I have explained the practical limitations of these conditions below. However, SCS is willing to prepare and comply with the noise management plan that has been proposed by the council. Given the location of the site, we consider that this is a fair requirement to ensure that the operations continue to comply with the permitted noise levels in the district plan. As regards the limit on activities during nighttime hours, condition 8, the proposed proposed condition 8 will prohibit any activities at the site during the nighttime hours between 10 p.m. and 7 a.m. SCS accepts that any activities that we wish to conduct at night must comply with the nighttime noise limits specified within the district plan. SCS currently has no intention to operate at night, but considers that any all-encompassing prohibition to be unduly restrictive and limiting.
You might be able to talk about activities you might do at night that aren't
Certainly. So,
noisy.
by virtue of what we do, we assess containers, which effectively is people determining the condition of containers for past and future use. We clean, we do minor repairs, we do upgrades. And whilst I am not aware of that having occurred outside daytime hours on a program basis, in the future, that may be something we wish to do. We do not envisage a scenario where we are going to be operating hoists in the middle of the night. A limit on altering the noise barrier. Under the proposed condition 10, SCS will be required to erect a noise barrier along the northern sealed edge of the site. This will be comprised of a continuous stack of containers at least 3 or 4 containers high, depending on the part of the site the barrier is located. Proposed condition 11 states that the noise barrier may not be changed more than 5 times per calendar year. For the purposes of this condition, a change in the barrier includes any movement of a container located within the noise barrier. This will be required to be recorded by SCS and made available on request by the council request. This proposed condition 11 is impractical as the noise barrier is essentially made up of containers that are part of SCS's operations, are owned by third parties, and do not remain permanently in place on the site. This means they will need to be moved from time to time as required by customers. SCS can ensure that it arranges the containers on site so that a noise barrier is created, and it can reduce the number of times that it moves the containers as much as possible, but restricting this to 5 times per year is impractical. I would go so far as to suggest that the recent noise assessment carried out by Powell Fenwick, report of the 22nd of June 2024, calls into question any necessity for this barrier. If SCS were required to erect a noise barrier with such limited movement, it would likely need to purchase a number of containers specifically for this purpose. This would be at significant cost to SCS Cube, as outlined by Richard in his submission. As regards a maximum of 2 hoists operating at any one time, Condition 13 proposes that a maximum of 2 hoists to operate at any time to manage noise levels. While SCS has operated the site with 2 hoists in the past, the current preferred deployment is 3 machines. Where hoists are operated at the same time, these are likely to be in different zones on the site. This will mean that the level of noise is not likely to be increased by the number of hoists on site. In addition to this, the new hoists are quieter. So again, I would not expect that additional hoists noise. In conclusion, SCS takes its obligations to manage its activities in compliance with the district plan seriously. SCS is careful to manage its activities in compliance with district plan limits, being mindful of neighbours and taking practical steps to reduce any noise issues that have arisen during operations. This has included being responsive to disclosed complaints and working with the council. As set out above, SCS is carrying out ongoing verifications of hours of operation being complied with, has carried out repairs to the site to reduce noise, and when permitted will further do so, has purchased later model quieter hoists, and has isolated a noise source, the generator, to reduce noise effects in accordance with recommendations from Powell Fenwick. Both council testing and independent testing has verified that SCS is operating within the limits set out in the district plan. On the basis of the above, I do not see any reason why these conditions need to be imposed, particularly when the conditions proposed are, in my view, correct. As I have noted, SCS would be happy to provide a noise management plan to ensure that compliance continues to be met going forward.
Thank you. Some good background. Thank you. Just curious about the noise management condition. It's probably more of a legal question. If consent hasn't been sought for this particular activity, but the conditions are specific to the activity, can a noise management plan be imposed as a condition of consent?
No, I don't think, I think probably not as a condition of this consent. I think this is something that Mr Timberton would need to organise with the enforcement division of the council
If it was
to agree to do that voluntarily to show compliance.
Yeah. As opposed to
being a condition on this consent, because this consent doesn't specifically relate to SCS. So I thought Mr Timberman is offering that to council.
Yeah,
and that's something I think he's proposing that he would deal with compliance.
Absolutely.
Just to show, to head off any risk that he's going to receive an abatement notice, effectively.
Yeah.
So that would be the mechanism by which that would be produced, rather than being a condition on this consent. Yeah.
And I know it's not relevant to the objection, but SCS at the moment is operating without the need for a resource consent. Is that correct?
Yes.
They're on the basis of compliance with discipline standards.
Yes.
Okay, no, that's really helpful. Thank you.
And the section 16 is a separate issue, but
well, that's right. Presumably,
that's enforcement. That's enforcement needs to deal with.
And presumably, if that monitoring did show there were consistent breaches, then there'd be a requirement for consent.
Yes. So you've either got to comply with the resource consent, or you've got to,
And we understand and obviously accept that.
And at the moment, we don't have any evidence to suggest that there's anything wrong with the district plan limits that would contribute, that would trigger a section 16 issue.
And I probably should have said at the beginning, just because I ask questions doesn't mean I've
I understand.
made my mind up either way.
Yeah.
That's fine.
So I suppose Mr. Peebles is here as a landowner applying for a resource consent. Mr. Timberton is here as an operator of a site, wanting to make sure that the council's enforcement team isn't going to come down on him for some suggestion that he's not complying with district plan limits or is breaching section 16. But those are two very different things.
Yeah. So great, thank you very much. But probably is a good time to take a break before we get into the technical evidence. So should we take a break for a quarter of an hour, come back at 11 o'clock? I'm sure everyone's had a comment.
So my full name is Samuel Henry George Jackson. I'm a member of the Health and Acoustic team. I'm an acoustic consultant with 3 years experience in New Zealand, 4 years experience in acoustic related fields in the UK. I hold a Bachelor of Engineering and PhD from Canterbury, both in mechanical engineering, and I'm a member of the Acoustical Society of New Zealand. In the field of environmental noise, I have expertise in measurement, modelling and prediction of noise in the context of the rules of the Christchurch District Plan, as well as other district plans across New Zealand. My experience includes the preparation of noise assessment reports that consider noise from industrial activity and vehicles. I provide the statement of evidence in relation to Braeburn Property Limited's objection to Christchurch City Council's decision on an application for resource consent relating to Port Link. Scope of evidence. In this evidence, I address the following noise matters as relates to the Braeburn Property Limited objection to consent conditions. Those items are the appropriateness and reasonableness of the noise limits at residential properties of the Christchurch District Plan, confirmation of continued feasibility of the current operator to meet district plan noise limits, and recent noise measurements undertaken of current container yard activities. And to summarise, my key observations and conclusions are that the noise limits set out in Table 1 of Rule 61521 of the Christchurch District Plan are the applicable limits and are appropriate and reasonable for addressing health and amenity matters as they align with other applicable guidance criteria. The container yard that operates on 320, 328 Cumberland Terrace is currently operating in a manner that is compliant with the noise limits set out in Table 1 of Rule 61521 at neighbouring residential properties on Long Street and Gould Crescent. This has been confirmed by recent noise measurements. It is feasible to continue to undertake industrial activities, including a container yard on 320, 328 Cumberland Terrace in a manner that is compliant with the noise limits set out in Table 1 of Rule 61521, and the noise management plan is sufficient to control adverse effects of noise from activities on the site. Notwithstanding the above, the residential areas around Long Street and Gould Crescent are generally exposed to background noise from existing industrial activities, particularly from the Bamford Industrial Estate, and road traffic noise, particularly from Tunnel Road. Conducting industrial activities on the sealed area of the ODP green space does not increase adverse effects due to noise, nor does it result in an unreasonable noise level provided that the district plan noise limits are adhered to. The proximity of the noise source does not impact the effects of the noise, provided the appropriate limit at the receiver at the residential properties is not exceeded. Draw upon some relevant criteria, the first being the Christchurch District Plan. The District Plan sets a framework for development and management of resources in the district in a manner that meets the goal of sustainable management of those resources. It includes objectives, policies, and rules for the management of environmental effects of land use activities. The following are the relevant noise rules as presented in the District Plan. Rule 6.1.5.2.1 sets boundary limits for noise from 320 to 328 Cumberland Terrace to neighbouring residential properties. And those noise limits at residential properties from the hours of 7 AM until 10 PM are 50 dB LAEQ with no LA max limit. And from 10 PM until 7 AM, those levels are 40 dB LAEQ and 65 dB LA. Also relevant, Sector Rule 6.1.4.1 states that unless otherwise specified elsewhere in this district plan, noise shall be measured in accordance with NZS 6801/2008, acoustics measurement of environmental sound, and assessed in accordance with NZS 6802/2008, acoustics environmental noise, except that provisions in NZS 6802 referring to special audible characteristics shall not be applied. Another relevant criteria from the World Health Organization. The World Health Organization publishes noise level guidance, including for residential properties to protect against annoyance and sleep disturbance. Level 4.1 from Guidelines for Community Noise published in 1999 by the WHO is reproduced in Table 2. Table 2 states that the specific environment being outdoor living areas, critical health effects being serious annoyance, daytime and evening, with a level of 55 dB LAEQ over a time basis of 16 hours. And for moderate annoyance, daytime and evening being 50 dB LAEQ, also over a time period of 16 hours. The values presented in Table 2 are the onset of annoyance at the corresponding levels, moderate or serious. That is to say, few people will be moderately annoyed with noise levels of 50 dB LAEQ, and few people will be seriously annoyed with noise levels of 55 dB LAEQ. Also relevant is NZS 6802/2008, which provides guidelines for the protection of health and amenity. Table 3 from section 8.6 of the standard is reproduced in Table 3, which states guidelines for upper residential noise limits during daytime are 55 dB LAEQ 15 minutes. Evening is 50 dB LAEQ 15 minutes. Nighttime 45 dB LAEQ 15 minutes, as well as at nighttime an LMAX level of 75 dB LAF max. Now, the definition of times of day are a matter for the relevant local authority and should recognise that a period of not less than 8 hours needs to be provided for sleep to ensure that at least a minimum acceptable degree of health protection. Inclusion of an evening period and its hours of application are a matter for the relevant local authority. And this clause is not framed as a consent condition rule or national environmental standard, should not be quoted for those purposes. The suggested format of consent conditions, rules, or national environmental standards. In terms of noise levels and reasonableness of noise, the district plan stipulates a noise limit of 50 dB LAEQ 15 minutes, with no penalty applied for special audible characteristics during daytime hours. This is consistent with the noise levels and WHO guidelines for the onset of moderate annoyance in outdoor living areas. NZS 6802 recommends a limit of 55 dB LAEQ 15 minutes during daytime hours to protect health and amenity, with the application of the 5 dB penalty in the case where special audible characteristics would apply. As such, the acceptable level for noise with special audible characteristics in NZS 6802 would be 50 dB LAEQ 15 minutes. This is consistent with the district plan limits, noting that NZS 6802 limits are therefore more lenient than the district plan limits, where the penalty for special audible characteristics is not applicable. The district plan noise limit at residential property, as per Rule 61521, is consistent with industry accepted guidance to protect health and amenity and to protect against annoyance. Based on the above, it is my view that a noise limit of 50 dB LAEQ 15 minutes at residential properties during daytime hours, that being 7 AM till 10 PM, is an appropriate limit for 320/328 Cumnor Terrace. With this limit, noise emanating from the site would not exceed a reasonable level. I note also that while there is no maximal noise limit during daytime hours, which is LAF max, this is inherently limited by the 50 dB LAEQ 15-minute limit. That is to say, a single unreasonably loud impact noise would result in the exceedance of the 50 dB LAEQ 15-minute limit. Feasibility of meeting noise limits. I completed a noise assessment for the operator of the container yard, and just for clarity, this is specialised container services. However, how Fenwick on our agreement was engaged by Pinnacle Corporation, which is our Cube Logistics, which is Mr. Timpson, in 2022/2023, to demonstrate that the container yard could operate at 320/328 Cumnor Terrace in a manner that is compliant with the noise limits of Rule 61521 of the district plan. Most recent version of the assessment is issue C, dated 20th of October 2023. The assessment was based on a reasonable worst case scenario with operations occurring within the sealed area of the ODP green space. I demonstrated that even in those circumstances, it was feasible for the container yard to operate in a manner that is compliant with the district plan. Notwithstanding the reasonableness of the district plan noise limits, I understand neighbouring residents have made complaints in relation to the shipping container depot. In situations like this, it is often appropriate to develop and implement a noise management plan to show how compliance with the district plan noise limits can be met. An NMP would include mitigation to limit noise exposure, including measures such as screening and yard layout. An NMP is an effective means by which the operator can enable ongoing compliance with district plan noise limits, and by which council can confirm that noise has been adequately controlled. A further benefit of an NMP is that it also provides flexibility should the operator require a change in operating method. For example, if newer hoists were purchased with a different noise output. Noise measurements for existing activities. I conducted noise measurements over a period of 4 days from the 30th of May 2024 to the 18th of June 2024. The results of these measurements, including subsequent analysis, was issued to the tenant and operator of the site in memo format on the 27th of June 2024, and I believe this is appended in Mr. Walsh's submission. Based on our measurements and analysis, the container yard, as it is currently operating, that is of the date of the issue of the memo, on 320/328 Cumnor Terrace, generates noise of 48 dB LAEQ 15 minutes at neighbouring residential properties, compliant with the district plan limit of 50 dB LAEQ 15 minutes. During the measurement periods, up to 3 hoists were operating on the site at any one time, whereas previously only 2 had been modelled. Additionally, containers were stacked in such a way that they screened the majority of activities on site. However, they did not form a continuous screen. Hoists were observed to operate between container stacks during periods of each measurement. The measurements support the conclusion of my previous noise assessment. Furthermore, the measured noise levels are lower than those modelled in the assessment, suggesting that I was conservative when modelling a reasonable worst-case scenario. I understand that council have also conducted noise measurements and that measured noise levels were similar to those presented in the I understand that Braeburn Property Limited intends to construct a 2.4 metre high acoustic fence on top of the bund that currently exists along the northern boundary of 320/328 Cumnor Terrace. With this fence in place, I calculate that noise exposure to residential properties from current activities would be no more than 45 dB LAEQ 15 minutes.
Just in relation then to your last paragraph, if your monitoring has shown that at present it's operating at around about 48 dBA, and if the acoustic fence would reduce that to 45, what difference or what noticeable difference would that make to someone, say, standing on a property? Would they notice a difference in noise if the fence was there or not there?
3 dB reduction, would say, is not typically noticeable. So subjectively, we would say that a 10 dB reduction would be viewed by most people as being a halving of noise level. So if you're from 50 to 40, most people would describe it as being half as loud. So a 3 dB reduction would be measurable, and some people would observe that as being a reduction, but certainly some people would not state that as being noticeably different.
And that would assume too that the noise is continuous. If the noise something generates is a continuous level of noise, then
correct. So the rationale behind the 15 minutes averaging of noise is to account for the fact that the noise generated is not continuous. Okay. It's going up and down constantly as hoists drive past, just the nature of a complex activity such as a yard. In terms of what the LAEQ or equivalent time average noise level mean, is an equivalent noise level that, if generated constantly, would be an equivalent acoustic level, sound energy, to the actual noise that's being generated, which is going up and down.
Yeah, thank you.
That's site activities.
was all I had. Thank you. That's really useful. I was going to ask if you might have included the green space, but we covered that. So it's
letting Mr. Jackson know he can probably go if he needs to.
oh, absolutely. No, that's fine.
If you want to
yeah,
stay,
and
you're
that-
welcome to, but if you've got other things to do.
If I'm not required, I'll head off.
No, that's and obviously it goes for anyone. Not bound, but if anything further comes up, we can always get a question to you. So that's fine.
Everyone.
Thanks, Sam.
I told him he'd be out of here by 11, so I'm 20 minutes over.
So good. Right, so
I'd skip straight to paragraph 7, but you mentioned at the start that this live stream, so perhaps I should read the
maybe we
introduction.
should read.
Yeah.
If anyone is online, they won't have.
My full name is Timothy Carr Walsh. I'm a resource management planner employed at Novo Group. Novo Group is a resource management planning, landscape architecture, traffic engineering consulting company that provides resource management related advice to private clients and local authorities. I hold a Bachelor of Science Honours degree and a Master of Science degree from the University of Canterbury, an associate member of the New Zealand Planning Institute, a member of the Resource Management Law Association and an accredited hearings commissioner. I have approximately 19 years of experience as a resource management planner, working in local and central government and as a consultant. I have particular experience in urban land use development planning in Greater Christchurch, predominantly as a consultant to property owners, investors and developers. Relevant to this matter, I've experience in processing resource consent applications, including preparing Section 42A reports and attending resource consent hearings for district councils. As a consultant planner, I've experience in evaluating development projects, preparing resource consent applications and plan change requests, and presenting evidence at council resource consent and plan change hearings and the Environment Court. I prepared the resource consent application for Braeburn Property Limited. I visited the site on several occasions and am familiar with the surrounding area. In fact, my parents live very close to it, so I know it very well. I grew up out that way. I'm adhering to the Code of Conduct. Paragraph 7, relevant to the objection, the resource consent application by Braeburn sought authorisation for works to enable industrial activities to be undertaken within the site, use of the sealed area within the landscape and stormwater area green space shown on the Port Lake Industrial Park Outline Development Plan, ODP, for activities permitted in the Industrial General Zone Port Lake Industrial Park, and a boundary adjustment primarily for the purpose of vesting an Esplanade Reserve. The application does not seek consent for specific industrial activities, including a shipping container depot to operate on the site. While the status of the application was discretionary, this was due to the adjacency of the site to a site of ecological significance, not in relation to any residential amenity matters. In terms of noise management conditions, in my view, Council has inappropriately used the resource consent application to address noise complaints made by neighbours in relation to the shipping container depot that currently operates in the northern yards of the site. Council should be satisfied that any activities undertaken within the site in compliance with the district plan noise standards is sufficient to ensure residential amenity is maintained in accordance with the level anticipated by the plan. While not relevant to the Braeburn application, the shipping container depot currently complies with district plan noise standards, even in the absence of the yet to be constructed acoustic fence. When constructed, the acoustic fence will further reduce the level of noise experienced in the residential zone, and the levels will be comfortably below the district plan daytime noise standard. I consider there is no risk in removing the noise management conditions, given that activities within the site are required to comply with the district plan noise standards at all times, or a resource consent would need to be obtained. In terms of height of shipping containers, condition that restricts height of shipping containers, I should say. I consider it inappropriate and unnecessary to impose a condition controlling the stacking height of shipping containers. The matter as to whether shipping containers are buildings is under challenge and scheduled to be decided by the Environment Court. If shipping containers are determined to be buildings, consent would be required to authorise any height infringement above 11 metres. If it is determined that containers are not buildings, the condition would unreasonably restrict an otherwise permitted activity. In terms of internal water connection network condition, I consider subdivision conditions should only require compliant water supply to be provided to the lot boundary, and firefighting requirements are already addressed by way of a land use condition. Addressing the application. The content of the resource consent application is an important consideration in deciding the objection. The application was carefully and deliberately prepared by the landowner to seek authorisation for works that would enable industrial activities to be undertaken on the site, and a boundary adjustment subdivision primarily to enable using of an Esplanade Reserve along the Heathcote River. The land use activities for which consent was originally sought included sealed hardstand and fencing within the ODP green space, use of the sealed area within the ODP green space for activities permitted in the Industrial General Zone, Port Lake Industrial Park, building height exceeding 11 metres within the 11 metre building height restriction shown on the ODP, earthworks, fencing and industrial activities within a waterway setback, and earthworks within a flood management area. Several amendments to the application were subsequently made to address concerns raised by Council. Of relevance to the objection, the application to exceed the 11 metre building height restriction was removed, and the proposed height for buildings within the sealed area of the ODP green space was reduced to 5.8 metres. The application was prepared to enable / better provide for industrial activities to be undertaken on the site now and in the future. It was not intended to specifically authorise any particular industrial activity, such as the current activities being undertaken on the site. The legal submissions had a plan of the yards, and so there's various activities that are being undertaken in each of those yards. Richard, I think there was a logging, storage, and
logging container. I actually note there's actually council storing the steel for the new stadium on site. Part of it.
So various activities in the yards. The only aspect of the application where consent was sought to enable industrial activities to occur in a manner not anticipated by the plan pertains to the use of the sealed area within the ODP green space for activities permitted in the Industrial General Zone, Port Lake Industrial Park. Rule 16.4.4.2.3 of the plan precludes buildings, fences, display of outdoor advertisements, parking of vehicles, or use for any purpose other than landscaping, passive recreation, or ecological enhancement within the ODP green space. The consequence of authorising activities permitted in the Industrial General Zone, Port Lake Industrial Park, within the ODP green space is that activities other than landscaping, passive recreation, or ecological enhancement can be located up to 16 metres further north than permitted by the plan. I say up to 16 metres because the exact extent of the ODP green space is difficult to determine with any degree of accuracy, as covered by Mr. Peebles in his evidence earlier. The Port Lake Industrial Park ODP is a relatively small scale plan, which makes it difficult to scale off and difficult to determine where to take measurements from. The extent of the ODP green space in the application represents a conservative, perhaps overly conservative estimation of the boundaries shown in the plan at Appendix 16.8.3, Roman numeral 1 of the plan, to ensure that the ODP green space area was captured by the application. Further information regarding noise. Council requested further information from the applicant on 18 January 2023, including the following item in respect of noise. An assessment is item 15. An assessment of noise is required in terms of the final earthworks for the site and the proposed industrial activity in terms of compliance of the rules and assessment of amenity effects, including along the river corridor and residential properties. The noise assessment shall be undertaken by a suitably qualified experienced practitioner. In respect of industrial activities, the response was that the applicant maintains its position that compliance with district plan noise standards can be assumed. Put another way, the applicant is not applying for consent to authorise existing or future industrial activities within the site to exceed the district plan noise standards. As set out in the application, the site has leased several tenants. Those tenants are required by way of lease agreements to comply with the provisions of all statutes, ordinances, regulations and bylaws, and the district plan noise standards included. Despite the above, Pinnacle Group, now Cube, the company that currently leases the yards closest to residential neighbours, has engaged an acoustic engineer, Pal Fenwick, to determine whether its operations comply with the district plan noise standards. Pinnacle Group has advised the applicant and council that it will provide a report on the matter to council in mid-April that year at the latest. If compliance is demonstrated, that will be the end of the matter. If non-compliance is identified, Pinnacle Group will apply for a resource consent to authorise the activity. This is clearly the tenant's responsibility, not Braeburn Property Limited. The council officer's report on the objection, I refer to that report as the officer's report, refers on several occasions to the applicant's acoustic assessment. The applicant never provided an acoustic assessment because it is the landlord and its only activity is leasing the land. As above, the operator of a shipping container depot within the site provided an acoustic assessment demonstrating that it could comply with the district plan noise standards. And as we heard from Mr. Jackson, it turned out to be a conservative modelling exercise. In relation to the further information request, council also asked the following noise related question. Item 16, does the experience and skill of the operator affect the noise generation in terms of the container operation? If so, how is this to be managed? The response was that the question was not relevant to the assessment of the resource consent application, as it was not an
The resource consent application wasn't made by the
it wasn't made by the operator. That's what I'm trying to say.
Yeah.
I'm sure I didn't see that there. I note that the shipping container depot was in operation prior to submission of the resource consent application, and that the operation had generated complaints from nearby residents about amenity, safety and noise alleged to be emanating from the site. The opposition to the use of the site for a container depot was well known at the time of the application and was the subject of media reporting. While the site has been zoned industrial since 2009, or actually might be 2010 when the decision was made, it is only recently that industrial activities have been undertaken at the northern end of the Port Lake Industrial Park. Until recently, the residential neighbours adjacent to the true left of the Heathcote River have experienced an open outlook and possibly less noise, noting that heavy traffic on Tunnel Road generates high noise emissions, and the nearby industrial zones on the true left of the river also produce noise. It is clear that the change in land use has driven the complaints from neighbours. The neighbours would previously have been used to a different visual and noise environment and are now having to adjust to the change. Had the site been vacant when the application was made, I do not see any reason why council would have taken an interest in noise matters relating to the operations of a particular operation. I anticipate that council would have been satisfied that any future activity would be required to comply with the district plan noise standards, and if it were unable to comply, that a resource consent would be sought by the operator. In my view, council has inappropriately used the consent to address the noise complaints rather than focus on the actual noise effects of the proposed activity for which consent was sought, which was to provide for current and ongoing use of the site for industrial activities in compliance with the district plan noise limits. I consider that the correct process to address any compliance issues would have been to engage separately with the shipping container depot operator and request directly from them that they demonstrate their operations were compliant with the district plan noise rules, noise management conditions. Council relied on the discretionary activity status of the application to impose the noise conditions. However, the discretionary activity status was a result of the adjacency of the site to an ecological corridor of the Heathcote River, not for any reason relating to residential amenity. The application sought to authorise several activities within the water body setback, including earthworks relating to the construction of the Northwest Bund and burying of a haul road, an acoustic fence on top of the Northwest Bund, and industrial activities located in the 30-metre water body setback. Because the Heathcote River is a site of ecological significance, discretionary consent is required in respect of the activities within the water body setback. On this matter, I note that only small areas of proposed industrial activities would be located within 30-metre water body setback adjacent to the northwest boundary, as indicated with red and white hatching on figures 1 and 2 below.
Yeah, I'll just keep this fine then, Tom.
Yeah, so in Appendix 1 shows the setbacks, water body setbacks relevant to the northern part of the site. Unfortunately, it's difficult to the size. It's sort of difficult to pick it up, but you'll see that the green line, which follows the alignment of the river, and there are two on the far right, the adjacent Tunnel Road, and then centrally along the northern part of the site to the left-hand side of the essential swale. There's two areas, and if we go back to figures 1 and 2, it's two areas where sealed surface would be within that 30-metre water body setback, and that's as per my interpretation of the 30-metre setback, which I note is different from council's interpretation. And at paragraph 33, I'm not sure whether I need to read it. It was in the objection letter. I can read it if you like.
No, I'm not happy for you.
But it's just my interpretation. If council interpretation was correct, then those red hatched areas would enlarge a bit, not significantly, but a bit. And my point is that it's relatively small areas, and potentially no industrial activity would be undertaken within those marginal areas. Paragraph 34. If the Heathcote River was not a site of ecological significance, the application would have had restricted discretionary status, and council would have had no discretion to impose noise management conditions. The matters of discretion in relation to water body setbacks are comprehensive, covering natural hazards, natural values, amenity and character, cultural values, maintenance access, and public access. None of the matters cover noise effects. Likewise, the matters of discretion relating to activities in the ODP green space at clause 16.7.322, landscaping in the Port Lake Industrial Park Development Plan, do not cover noise. Unsurprisingly, the explanatory information and policy framework in the plan relating to sites of ecological significance is focused on identification, recognition, protection, and enhancement of Indigenous biodiversity. The discretion afforded to council by Rule 6644D1 is clearly meant for assessing ecological matters. Relying on legal advice, the officer's report states that it is the activity that has been assessed rather than the contravention of a rule, and points to the aspect of the application that seeks consent for industrial use within the ODP green space which moves industrial activity closer to sensitive residential receivers. The officer's report states that this brings the noise effects of the industrial uses into council's jurisdiction. I consider that the proximity of the noise source to the receiver has no bearing on its effect, provided it is at the same level when it reaches the receiver. Put another way, there is no difference in effect between a noise measuring 50 dB LEAQ at a receiver that was produced 20 metres away and a noise measuring 50 dB at the same receiver that was produced 120 metres away. While I agree that it is the activity that requires assessment rather than the contravention of a rule, the relevant activity applied for is not a shipping container depot. The application seeks consent for any activities permitted in the Industrial General Zone, Portlake Industrial Park, to be carried out on the sealed area within the ODP green space. The noise management conditions that have been imposed are specific to a shipping container depot and would not be appropriate in relation to any other permitted activity. Notwithstanding my view that the conditions are unnecessary, and my footnote there just directs the Commissioner back to the objection letter. If the shipping container depot were replaced with another industrial activity, a change or cancellation of conditions application would be required. This highlights the overly specific nature of the conditions in relation to the generic activity for which consent was sought. In my view, the relevant assessment in terms of effects on neighbouring residents resulting from the use of the sealed area within the ODP green space ought to have been focused on visual impacts. In this regard, I note that the visual effects of these on these neighbours were assessed as being less than minor, as recorded in the decision. In terms of noise effects, Council should be satisfied that compliance with the district plan noise standards is sufficient to ensure residential amenity is maintained in accordance with the level anticipated by the plan. Objective 6.1.2.1, adverse noise effects of the plan, seeks that adverse noise effects on the amenity values and health of people and communities are managed to levels consistent with the anticipated outcomes for the receiving environment. Its relevant associated policies, and these include 16.1.2.1.1, managing noise effects, and 6. Oh, sorry, that should be 16. That's a mistake there. It should be 6. 6.1.2.1.1, managing noise effects, and 6.1.2.1.2, noise during nighttime. Require that noise effects be managed by limitations on the sound level, location, and duration of noisy activities, and ensuring lower noise levels during the night. These policies provide the basis for the district plan noise standards, including at Rule 6.1.5.2, which requires noise levels received in residential zones to be no more than 50 dB LAEQ during daytime hours and 40 dB during the night, with an LA max of 65 at night time. As per Mr. Jackson's evidence, these levels are underpinned by guidance from the World Health Organization and contained in New Zealand Standard 6802/2008. Mr. Jackson considers noise levels received in residential zones within the district plan noise standards are reasonable. Policy 16.2.3.2 provides for managing effects through specific controls, but also recognises that amenity levels of residential zones adjoining an industrial zone may not be the same as further away from the industrial interface. In this case, the amenity of the residential neighbours adjacent to the site is higher than experienced at most residential industrial interfaces in the city. It is far more common for a residential zone to be separated from the industrial general zone by only a road or a fence rather than an expansive river corridor. Further, the Portlake Industrial Park ODP provides additional features such as generous land areas of landscaping that increase residential amenity at the industrial residential interface. I'll pick up a point there. I think I remember reading in Brookfield legal opinion that was appended to the officer's report that the ODP features, I hope I'm getting this right, but the ODP features were in place exclusively for residential amenity matters, but my understanding is that that they're also for ecological reasons as well, and perhaps more so for ecological reasons, given its adjacency to the site of ecological significance. It is also relevant to note that the industrial general Port Lake industrial zoning was put in place in 2009 or 2010, following the process prescribed at Schedule 1 of the Act. The plan change process did not identify the need to impose more stringent noise standards for the benefit of the residential zones to the north. The existing district plan noise standards must have been assessed as providing appropriate protection at the time. Compliance with district plan noise standards. While not relevant to the Braeburn application, I can confirm that the shipping container depot currently complies with the district plan noise standards, even in the absence of the yet to be constructed acoustic fence. I note that the activity also complies in the absence of the container wall, which is the subject of conditions 10 and 11 of the resource consent. While the acoustic fence was proposed in the application, the container wall was not. I refer to a memo from Howard Fenwick dated 27 June 2024, included in Appendix 2, which concludes, I'm not sure again whether you would like me to read that or...
No, I'm happy.
Anyway, the gist of it is that the current activity complies with district plan noise standards as you heard from Mr. Peebles, Mr. Temperton and Mr. Jackson. There was one of the days of testing that was in non-compliance. That was remedied and subsequently retested, and it complies.
Paragraph 45.
Paragraph 45. As noted in the memo, the monitoring found it. Anyway, I've covered this. Paragraph 45, I've covered. 46. The recent noise monitoring undertaken by Powell Fenwick is corroborated by the findings of noise monitoring, which I understand has been undertaken by Council on several occasions from mid-2022. As noted in Mr. Temperton and Mr. Peebles' evidence, the results of this noise monitoring were not shared with Braeburn nor the shipping container depot operator. Further, on 15 May 2024, I received correspondence from a Council consents officer asking, how do we have a position on an objection to the noise matter without seeing what you claim shows a compliance without an acoustic fence? The question appears to be disingenuous given Council knew the shipping container depot was operating in compliance with the district plan noise standards without the acoustic fence. I assume that the officer had not been made aware of the Council monitoring, otherwise the question would not have been asked. As per Mr. Jackson's evidence, the installation of the acoustic fence, which will occur when the objection is decided, will further reduce the level of noise experienced in the residential zone, and the levels will be comfortably below the district plan daytime noise standard. In terms of Section 16 matters, the officer's report points to Section 16 of the Act as a justification for the imposition of the noise management conditions. As per Mr. Jackson's evidence, compliance with the district plan noise standards ensures the protection of health and amenity and protection against annoyance. On this basis, I consider that an activity that is compliant with the noise standards will also be upholding the occupier's Section 16 duty to avoid unreasonable noise. While the shipping container depot noise emissions include bumps or thumps, these do not breach the district plan noise standards, even without the acoustic fence. In any case, if Council has concerns relevant to Section 16 of the Act, the appropriate course of action would be to take them up directly with the operator. It is not necessary nor appropriate to address those matters via this resource consent. As noted in Mr. Temperton's statement of evidence, the shipping container depot operator is willing to provide a noise management plan in relation to its activities. The officer's report, and I'm not sure, just on that point, and it's more of a legal question, is whether council actually has powers under section 16 to request a noise management plan pursuant to section 16. I'm not sure what the answer to the question is. I mean, the operators said that they would willingly provide that, but there may be a power to request it.
I don't know that.
If there's a legitimate
Mr.
concern.
Temperton doesn't want to face an abatement notice. I think he'd rather head that off and engage with enforcement so that they can be satisfied there's no need to issue one.
Yeah.
I think it's being proffered by Mr. Temperton, but not as part of conditions on a resource consent.
Yeah.
That's correct, is it, Aaron?
Absolutely. And also, without endeavouring to be on a soapbox, we maintain that we have endeavoured to be responsible and reasonable neighbours to affected residents, and we see the provision of a noise management plan as a further example of our responsibility in taking what we consider to be a responsible approach.
Paragraph 52. The officer's report suggests that because there have been complaints from neighbours, residential amenity is not maintained to an acceptable level. I disagree. As discussed earlier, it is my view that residential neighbours near the interface with the industrial zone are yet to adjust to the realities of living adjacent to industrial activities because the site has only recently been fully tenanted, and that the residential amenity they experience is higher in this location when compared to most other residential industrial interfaces, which are commonly separated by a road or fence. I think that the river corridor in that location is around about 80 metres wide.
That'd be right.
Richard, is that?
Yep.
Something about that. And obviously there's more separation distance afforded by the OUP green space. The officer's report raises a concern that the requested deletion of the noise management condition, quote, creates the risk that residential amenity is not maintained. I consider there is no risk in removing the noise management conditions. Activities within the site are required to comply with the district clean noise standards at all times. In terms of height of shipping containers, land use condition 22 is specific to the current shipping container depot operation within the northern part of the site. The application did not specifically seek consent for this activity. However, the condition is of assistance to the consent holder in that it establishes the sealed surface of the 11 metre building height area as the level from which building height is measured, rather than the lower original ground level, which is up to 1 metre lower than the sealed surface. Therefore, as per my correspondence with Council on 21 May this year, the consent holder requests that the condition be amended as follows, with shipping containers and or struck out from the condition. The reference to shipping containers is requested to be deleted because restricting the stacking height of shipping containers by way of consent condition is inappropriate. The matter as to whether shipping containers are buildings is under challenge and scheduled to be decided by the Environment Court. If shipping containers are determined to be buildings, resource consent would be required to authorise any height infringement above the 11 metre building height limit pursuant to Rule 16.4413 RD1 of the plan, and the necessary resource consent application would need to be made. If, however, it is determined that containers are not buildings, the condition would unreasonably restrict an otherwise permitted activity. Referring to a council visual assessment of the application, the officer's report states that if containers were to be stacked at a greater height than 11 metres above existing ground level, depending on the configuration, this could have the potential to create minor or more than minor residential amenity effects. The accuracy of this statement depends on whether shipping containers are determined to be buildings. If they are, any resource consent application to authorise stacking of shipping containers higher than 11 metres would be assessed against the relevant matters of discretion at clause 16.7.11 plan. These matters provide for full assessment of the actual and potential adverse effects of overheight buildings. The officer's concern regarding the potential of shipping containers to create minor or more than minor residential amenity effects would be assessed via the resource consent process. The reference to shipping containers was added by the Commissioner without any proper assessment against the matters of discretion at clause 16.7.11. If it is determined that shipping containers are not buildings, the actual potential adverse effects of stacking shipping containers above 11 metres would be anticipated by the plan.
Just for this thinking, do you think that's where, and again, not trying to get to the Commission's head, but do you think that's an attempt to recognise that if buildings are limited to 11 metres, other things that are higher are going to have a similar degree of effect? And to say, if you're looking at a permitted baseline time argument, is that, and I understand if they're not buildings, then it's irrelevant to a degree because there'd be no consent needed. But do you think?
Well, I think that's probably what he has been doing in his head, but the simple reality was that wasn't what we applied for, and all the information to carry out that assessment properly, and as against clause 16.7.11 wasn't. You can't just say, oh, in my head it's similar, so therefore I'm going to decide. That wasn't the assessment he was being asked to do, and the information was not in front of him to do that.
Yeah. No, that's right. And I guess that just wondering whether it was an attempt to try and head off if they're not buildings, and you can go up to whatever height you want within reason.
I'm sure that that's what he's attempting to do, but I'm absolutely sure. But there's no basis on which to do that, and we were specifically not doing that as part of this application.
And a consent would be required because, I mean, just elaborating on that is that if casting forward, and if the court finds in favour of council's interpretation of whether a shipping container is a building or not, that's highly likely, and I've talked to Mr. Templeton about this, it's highly likely that a resource consent application would be submitted. And there are multiple, there's a stacking sequence that would form the basis of that application. And it was sort of along the basis of what the original proposal was, is that you sort of progressively stack away from the neighbours so that the line of sight, even though the containers are stacked high, there's no greater or certainly not a significantly greater visual effect from those receivers. And so but it's against that proposal that those assessment needs to be made. There is no proposal here to make that assessment against.
And all of that information was not for the Commissioner because we've withdrawn any. So if it has been taken into account and it's being taken into account now, that would be improper because it's not relevant information. So I mean, we accept that if we lose, we're going to have to make an application for resource consent. I mean, and that'll be done properly, and there'll be a proper assessment, and it'll be a proper assessment against clause 16.7.11. But this is not the time and place for that assessment to be made on the basis of shipping containers would be similar to buildings, therefore I'm going to decide. That's
Paragraph 60 in relation to the internal water network. The officer's report records that agreement has been reached between the consent holder and council officers in respect of land use conditions 6 and subdivision conditions, all of those ones, including 4.2. This is not the case in respect of subdivision condition 4.2. As per the objection letter, subdivision condition 4.2 specifies design requirements for the internal water network in relation to firefighting. The subdivision should only require a compliant water supply to be provided to the lot boundary. Firefighting requirements are reduced by way of land use condition 23. Council's proposed amendment to this condition does not adequately address the objection. Consent holder understands that if the site were to be subdivided further, the water network, the existing water network that's been in place, which I understand meets council standards, would need to meet the appropriate standard before it could be accepted for vesting in council ownership. So the risk here lies with the landowner. If the water network that's been installed isn't up to the standard, then it would need to be upgraded, or it wouldn't be able to be vested in council, and that would be detrimental to in relation to any further subdivision application, which may or may not come. It may not come. Depends on the landowner's intentions for the rest of the
Yeah. So just in relation to your paragraph 60, then that's my understanding that ordinarily through a subdivision process, services get provided to the boundary. It's then the subsequent lot owner's responsibility to take those services from that point to their site, however they choose to lay it out.
Yeah. So my suggestion was that requirement, or that the concern, or the note could be included as an advice note, and that'd be fine. In terms of conclusion, I consider that the objection should be upheld, not in the full.
Just going back to this visual assessment, part of our concern is that I understand in the objection application what council is now pointing to, that the commissioner had available to him was a landscape, was the original visual assessment that had been done with the original application, and council's peer review of that started the 11th of August 2023. So that is prior to the amendment of the application, which removed all this material. So I'm saying it shouldn't have been in front of the commissioner.
And I haven't had time to read it.
Yeah, well, and it shouldn't be in front of you either. No. So that's, it's.
Understand the point.
Yeah.
So thank you. Covered the questions that I had.
Just going back to, I'm just clearing up this building height condition, the condition 22, forget about the shipping containers. And so the purpose of having that condition in was really just to get clarification on where you measure. So we don't have an objection to that being clarified, it's just the way it's worded at the moment.
Just with the
so we do see benefit in the condition being in there for that clarity.
Yeah. As I note in the objection letter, I think in a footnote in the evidence is that when the subdivision is completed, it's not really that there's no benefit in the condition any longer.
Yeah, it covers you for that period between the seal now until it's till the
and the interim, and sometimes those things take a wee while, and it's a live site, so it's worth it for compliance. To have that in place. That was Ms. Wilson's recognising that situation and providing for it, which was helpful.
So the next thing I was going to say is that it could be reworded to say something along the lines of for the purpose of determining compliance with height limits, you shall measure it from, or something like that, rather than the way it's been drafted at the moment. That's the purposes of it being there, is to provide that clarity, not to deal with an amenity issue. And I don't know whether Rachel's got any suggestions about how that could be. Yeah. Because the way it reads at the moment, it's there to deal with amenity issue rather than to deal with how you measure it, which is what was intended.
Understand that. Thank you. Thank you. You've covered the things I was going to ask as you've gone through and as we've been chatting, so that's nothing. Which brings us to the end of your Unless there's something else you want to raise.
No, nothing.
All right.
Oh, actually, there was one other thing. I've just got a copy of that case I referred to you about the difference between owner and occupier, the Sound Incorporated versus Whangarei District Council. The relevant paragraph I'll give you that is paragraph 48, and it says it was open to the council, that's the landowner, to make support for its tenants' application contingent on meeting all statutory and regulatory requirements, including those imposed by the district plan. So that's exactly what, that's as far as the lease goes at the moment, has exactly the same wording. In short, the landowner is entitled to assume the tenant can conduct its operations lawfully. And then it says, relatedly, section 16 in particular of the Resource Management Act applies to the occupier of land, not the owner. And if granted, the leased nest in that case would be the occupier. It goes on to discuss section 17, which is a different issue, but I just wanted to refer you to that particular paragraph.
Just able to say just one more thing, just you know, I purchased the land as industrial land. We just changed the zone. You know, during the process, there was existing consent for filling within 20 metres of the waterway. We worked cooperatively with the council all the way through. So we had weekly meetings with council in regards to where we were putting the hard fill and fencing and bunds, etc. But not only that, we also recognise the interface, you know, with the river and the residences, and to that effect, we created a bund and proposed an acoustic fence and planting to recognise that interface. You know, we did that without any requirement to do so. It was just done because we felt we were responsible neighbours. And this was all planned prior to the advent of the container lease. So whilst it's, I think that it's the distance is between 100 and 120 metres in total, we are, you know, I don't buy land adjacent, industrial land adjacent to neighbours because of the difficulties. This land was 120 metres away, but we still recognise the interface. So that's why we proposed the bund and the fence without realising the implications of the bund and fence actually on the ODP, because no one at the point we were dealing with council could tell us where the boundary of the ODP was. So we were dealing every week with the council on site, going over all the earthworks. We also provided, just to show the cooperation, the council approached us about wanting access for the cycleway. You know, we provided free access and a free easement to the council for the cycleway. We didn't ask for any compensation or any money to do that. We signed the document, gave them the easement. We gave access to the local group for planting along the waterways. So, you know, we feel we're a very responsible corporate citizen. We've gone out of our way to actually ensure that the development has the least effect on the neighbours. And it is of concern to us that we've been betrayed, have gone ahead and done work without authority and all that sort of thing. That is not the case. We take our responsibilities very, very seriously.
Which is why the application was to clean up the abatement notice issues, and that would relate to any industrial site, that activity that might want to come onto the site at a general level, was to deal with the activities that have been undertaken that weren't contingent on any particular type of tenant turning up.
So just to give you an idea of the impact, we actually had a situation where a local high school actually put out a task for their students, holding up different people. They had a local Ngāi Tahu representative, they had a fisherman, and they had Richard Peebles from Brayburn Property, who was going in and destroying the waterways and building over ecological corridors and that sort of thing. So that was put out to a school for holding me up as the villain. And where's, you know, I don't think there's another container park in Christchurch, including the Christchurch ones, which control the water and treat the water like we do. I mean, there's most container parks are on gravel basis. You know, this container park has been built to control the water, to treat the water, and it's got the ecological corridors. I feel like I've been beaten up and bullied.
That's understood. All right, well, that then brings us to council. I know we've had legal submissions pre-circulated, which I've read, I assume was ever.
Yeah.
So up to you and how you want to proceed in terms of.
Yeah, so we'll probably get, Andrew, do you need any time or are you ready to get straight into it?
I'm ready to answer any questions the Commissioner may have arising from those pre-circulated submissions, but I would encourage you, sir, to also read appendices 4 and 5, which are attached to Ms. Wilson's report, because the submissions are just an extremely truncated version of those two opinions.
Yep. No, I've read those. Thank you. I didn't have any particular questions, but I am see whether you had any comments in response to what you've heard this morning. I am curious to ask about the monitoring work that's been done by council and whether that was a factor in the reporting or whether that's something that wasn't available when the reports were done.
Ms. Wilson will address that, sir.
Yeah, no, I expected that.
Yes.
But I am curious just to see whether you have any comments in response to or reaction to what you've heard this morning from council's legal perspective.
I think, as Mr. Walsh has acknowledged in his statement of evidence, one of the activities for which consent was sought was those activities permitted in the industrial general zone to take place in the green space setback, and he's acknowledged that. So that's a trigger, we say, for the full-blown discretionary activity assessment. And that being so, the council or the commissioner in this instance wasn't constrained to the types of conditions which he could impose. On the subject of the occupier, having sought consent along those lines, SCS, who is going to occupy the site under its lease, has available to it all the rights which are afforded by the consent, and the relevant noise conditions are directed at that operator / occupier. So I don't consider the fact that Braeburn is not the occupier to be determinative with respect to the weight that Section 16 might be given by an assessing officer and by yourself hearing this objection.
So, and presumably, though, SCS, irrespective of whether this consent was sought or not, SCS could establish on the site with a certificate of compliance if they could prove compliance with district plan standards. It wouldn't necessarily be constrained by this consent.
No, the only constraint would be whether compliance with the district plan standards per se achieve the PPO.
In respect of noise.
In respect of noise, yes.
Yeah. But in theory, then, if SCSA in this case, and I know this isn't necessarily directly related, but if they have information that shows that they comply, they wouldn't need a consent because it's established unless another party demonstrated they didn't comply through complaints.
Yes, I agree with that. Yes.
Yeah. So I guess the issue is, and I know council's view is that because there was a discretionary activity, that it's fully discretionary.
Yes.
Enables it to impose noise conditions. But if the application that was made isn't for a particular activity, but is enabling of future activities irrespective of what they might be, can you impose conditions on this consent that would impose a constraint on future occupiers if there's not an effect that's needing to be managed at this point in time?
Well, if you started off with the blank canvas, as in no activity on the site, I'd tend to agree.
But if there is an existing activity on the site that complies, does that automatically necessitate putting conditions on the underlying consent that would impose further restrictions on it?
Doesn't automatically require it, no.
Okay, so I guess the thrust of your submissions, as I understood them, was that the council can impose the conditions because it's a fully discretionary activity, so that it opens up
Yes,
the assessment. And secondly, then that the noise conditions are necessary to address potential effects from activities on the site, even if some of those existing activities are permitted.
that's correct.
Did you have any? I'd have to go back to your submissions, but did you make any comment on that then in terms of the Newbury test and reasonableness? If an activity is complying, is it reasonable to impose conditions on them that are more stringent?
Yes, we did.
Okay. All right, I'll go back and reread those. Okay. Yeah, so I guess the matters have been pretty well traversed in both your own submissions and Ms. Appleyard's, but if a landowner who owns a landowner leases their site and the conditions in the lease require adherence to district plan conditions, including noise, and if that applicant, and if an activity, as in this case SCS, then say, well, actually we do comply, and here's the assessment relating to that. I guess isn't it reasonable in that case then to impose further restrictions on an activity when that activity itself wasn't part of the underlying consent? I'm just struggling to understand, I guess, the link between the landowner issues and the leaseholder issues when the activities that the leaseholder is undertaking are independent of the consent held by the landlord.
Well, here they're not, because there's a consent sought to undertake industrial activities in the green space.
Presumably, though, those activities could be undertaken by SCS or by someone who wants to run an automotive repair business or other activities. If the noise conditions are constructed to relate to the container activity, shouldn't they be properly imposed on any consents if they are required by SCS?
Well, the fact is that permitted activities can't be undertaken within that green space setback without a consent. I want to be able to undertake the activities which can be undertaken elsewhere on the site in that area as well. To do that, they need a consent. That's been sought.
Yeah, agree, accept that. So if, okay, thank you, understand that. So in respect of then the height issue,
yes,
Ms. Appleyard's taken us through this morning quite carefully the process that they're currently in relation to height in shipping containers and whether they're buildings or not. Given that the application made by the application that the applicant has sought doesn't include a request to breach the height limit. I'm curious as to if shipping containers are deemed to be buildings, then obviously the 11 metre height limit applies and consent will be required. If they're not buildings, then there's no such restriction.
but if there are effects on the environment arising from their presence on a fully discretionary activity consent, you can decide whether those effects need to be conditioned or not.
Okay, all right. Thank you. Just one last question. I guess the evidence we heard from Mr. Peebles and others this morning talked about the cost of complying with those conditions. Given that the activity or the SES activity is compliant with district plan provisions, is there a question in your mind then that those conditions might be unreasonable given the cost placed on a complying activity?
Yeah, I think we have to factor that in. Yes.
Yeah. Okay. All right. Thank you. I think that's all I had for you at this stage, Mr. Green. There may be more that come out of discussions with council.
Thank you, sir.
Officers. Yes, thank you. Right. Yes, awesome.
I'm just checking that I don't need to read them.
You don't need to read your report from. No, it's been pre-circulated to everybody.
Yeah.
We'd be here till
yes, we will
a long
be.
time.
You don't need to. So I'll firstly just draw to the attention of that condition 4.2 in the subdivision. As I mentioned that I assumed that there was agreement because I sent an email to Mr. Walsh just indicating a new updated condition to reflect his concerns. Initially, that condition was to relate to the vesting of future vesting of infrastructure to make sure that everything was up to scratch when that happens, because we were unsure when it would happen. The applicant mentioned back that that wasn't appropriate, and they weren't sure when they would vest that road because that's a requirement of the ODP, but they addressed that as a non-compliance in the application. So we went back to our three waters to get a condition. So there is a bit of differences between the land use conditions and the land use rules and the subdivision rules with water supply for firefighting, for example. The one requires compliance, which is the land use, that they have availability to water fire supply. The water supply in 8.6.7, it requires two things. All allotments shall be provided with the ability to connect to the safe potable water supply, and then the second is provision shall be made for sufficient water supply and access to water supplies for firefighting with the New Zealand Fire Association. So the 4.2 amended condition, which is in my report, that was to reflect those rules to ensure compliance, as well as ensuring it's up to the private road is up to the standards we require, which are not going to be vested. And then we have an advice note below mentioning about vesting. So if the applicant has any suggestions of amending that, I can forward that on to our free wardens. But the advice what I've received is from the free wardens, so I don't have any comment because I'm not a specialist. So if any more investigations of that, that's absolutely fine. The next thing is about the noise. So after the issue of this consent, before it was upheld, and with community discussions, there has been some monitoring occurring in the background with compliance. I didn't have the raw data of that, so I just assumed, just knowing that it was permitted. What I was waiting for on the objection was to receive updated information from the statements of the objection. So I haven't got any comment really about the noise until we kind of get this reviewed further. So we're just waiting for that evidence to be received, which I presume would be received at the hearing. I'm happy to provide the noise information. I've just contacted the compliance team, so I can forward that on to all parties involved.
Yeah, I guess my question would be, if you had access to that monitoring information that showed compliance, would that have made a difference to the way you assessed and recommended
the objection? I think it's probably a factor, so it's probably aligned with Mr. Jackson's information, so probably assessing those too. So I'm happy to provide a post-minute comment on those two elements, just to see, because it's just understanding. With the initial Powell Fenwick report, it said that it was compliant on the basis that they would do certain things to mitigate. So that was the acoustic fence, a noise barrier, restricting nighttime opportunities, and noting that their activity would only have 2 hoists. So that's why the conditions have been enforced the way they have, because it was what the recommendations are. We have added other conditions as well, which were to try and cater for what our AES assessment mentioned. So that was minimum, shortening the intervals, but regardless of that, whatever information which has been provided by Mr. Jackson, that can be re-reviewed and to understand. So I can't provide full commentary until that's been reviewed by an acoustic specialist, because I'm not a specialist.
Yeah, no, that's
And obviously, except that Pal Fenwick's original was a modelling scenario, so what we've got now is actual.
Yeah, so that's
And that the information wasn't provided by the applicant as to what the applicant was doing. It's that's provided by SCS, so it wasn't part of the application. That's so when you talk about the mitigation, it was never proposed as part of the application because the application wasn't being made by SCS. It was an SCS's report, but so that seems to be where the problem is, that it's been assumed to be the applicant's report, and the description in there about how the activity was being undertaken has then been translated into conditions on this consent, which weren't proffered conditions because
it wasn't part of
because it wasn't Brayburn's activity. That seems to be where
that's
the problem has arisen, that what was given as a description of how SCS was operating have been regarded as mitigation and then been translated into conditions on another party's consent. That seems to be how we've ended up there.
And from the operator's perspective, my recollection of the initial Pal Fenwick report from May 2023, which may not be sound recollection, was that the activity was modelled reflecting the should there be a presence of the acoustic fence and other mitigations based, I believe, around the fact that there was a term, I apologise, I can't recall it, but a term where there was kind of marginal compliance. And I think that Pal Fenwick suggested that some mitigations, if necessary, could then be the container wall. And in May 2023, again, my recollection was we were only operating 2 hoists on the site.
And I think the crucial distinction here is that they were recommendations to SCS about how SCS didn't end up with an abatement notice. They were not a report put forward by the applicant as to conditions to go on its own consent. That seems to be where the problem's arisen.
Yep. Okay. Did you have anything else you wanted to cover? I don't.
I think everything's probably been covered. Just with the visual assessment, I just noted that in my section 104, it wasn't mentioned that it was based probably on what the information provided in that noise report, that there would be up to 4 containers. So that's and council's interpretation has been that they are buildings, so we cater for that meter, and it's just noting that we referred to that assessment as a permitted baseline. So that's where my comment in the objection, that if it was to change a configuration, it would just need a reassessment to understand the implications of that, noting that there is a legal procession about whether buildings whether containers are stacked as buildings or not. Yeah, other than that, I don't think there's much else really, just what's already in the report.
No, I think the issues raised are pretty well understood. I think they're pretty well covered by both parties. So I didn't have any other questions because we've traversed most of them and questions to various people throughout the day. The issue is, I guess, where to from here. And I understand you need to have what's been presented assessed by the council's voice people.
Yeah.
So,
am I able to just say one thing?
Sure.
I'm still a bit confused about the council testing and the relevance and whether that was available at the time of the report. So, there was a community meeting, I think, in March, where they talked about the testing, which we've been sent, which you were at, where they said that there'd been testing and it was compliant, and that was followed up by a community newsletter a month later where they'd done further testing and it was compliant. And I'm still can't understand, with the evidence and the obviously substantial testing, it was never referred to in any report and wasn't provided to us, and that hasn't been. I don't think that's been adequately addressed, and I know this isn't a court of law, but even in fairness, that evidence obviously was available to council, wasn't made available to us in our application.
And it wasn't available to Mr. Temperton and then he's had to fly down and come here today to defend his own compliance with district plan. So there's a considerable cost in him having to come to do that. And he's not really actually involved in this application. He's defending himself against potential for enforcement action. So he's not even the applicant.
Yeah.
That's
No, I certainly can't speak to why it wasn't available, but it certainly would help if it had been.
I feel the council knew it was compliant, but yet didn't acknowledge that in the report. In fact, went further and required us to have other conditions, knowing very well that it was compliant activity. And I frankly, having worked closely with council for a long time, I'm quite disturbed.
That being the case, and regardless of that, page 9 of the officer's report, paragraph 20 and bullet 1, 2, 3 gets to the point that Rachel was making before about peer review. The statement being that the applicant's statements do not provide enough surety to warrant the changes to conditions sought. If the applicant supplies further documentation, a peer review from an acoustic specialist is required to understand whether residential amenities in section 16 have been adequately addressed. And I would suggest that that's not required, because we've already heard from Mr. Jackson that they are appropriate. The previous AES assessment agrees with that premise, and in terms of the district plan noise standards being the appropriate benchmark for whether noise is reasonable or not. And now although there needs to be some clarity about council having demonstrated or found compliance. So I'm not sure that there is actually a need for a peer review in this.
Well, the other point is that AES could have been asked whether its district plan standards were sufficient to protect residential amenity well before turning up here. Those are its limits in its district plan, and if they think that they're wanting in some respect and there's some section 16 problem, that could have been done. That could have been done well before now.
And if it's and going back to my original point, is if there's a section 16 matter, then that can be appropriately taken up with the operator.
With the operator. Well, that's right.
Through enforcement.
I understand that. Whether issues have become tangled, I understand that. I guess in terms of council's response and then your closing, I am curious as to whether the council's position would have been different had they full visibility of all the monitoring results.
Yes, I think that's one thing. But asking council to go back and say, are our district plan limits reasonable and did they protect residential amenity? If we're going right back to re-asking AES that question, I have a real concern with that.
I think you have to assume they are, because they've gone through the full district plan process.
Yes, so if there's just going to be some rule run across what we've produced to confirm that the monitoring information as we understand it is correct, and that council doesn't hold some different information, and that there is compliance, I don't have a problem with that.
Yeah.
But a relook at whether the district plan limits are reasonable to protect amenity, and I'd have a real concern about that.
No, great, and I wasn't anticipating. I'm purely curious as to whether
are they compliant?
Are they compliant?
Yeah.
The information that's been provided suggests that they are.
Yeah.
And if that's accepted, then does that have a bearing on council's view on those conditions? Yeah. Is the extent of what I'm curious about.
Yeah, and what I don't want is we don't think our district plan limits are sufficient.
No, this isn't the form to test district plan limits.
No.
That they are what they are.
Yeah.
Yeah. Assuming then we get a response from council, and I'm not expecting you to. I'm curious to have a response, and then obviously we'd have that removed to your closing. It's not something I think would warrant reconvening or going around the parts again. But I would like some additional commentary based on the monitoring that's been undertaken, given it hasn't been tabled, and accepting too your concerns that it's not part of the consent that was sought.
But having said that, we are in a resource consent hearing for Braeburn, but Mr. Templeton doesn't want to be on the receiving end of an abatement notice either. No, great. So so we're dealing with two issues here.
Yeah, and I guess that's, as part of your closing, it'd be helpful, I think, to if the objection was upheld, to set out a process that the noise management plan could be, how that would be addressed through this consent, because conscious you can't impose a condition on a third party.
Because Mr. Peebles can't require Mr. Templeton to do it. So that's the.
And whether it's an OGA type condition or something, I'll leave that to you. Probably better have a bit of legal brain than I do. So I guess that's brings us to an adjournment for today. In terms of the timeframes, and I know you've got the declaration coming up in September, so we will have this resolved.
Yeah, well, I mean, the whole purpose of this exercise was to get this abatement notice and get it all cleaned up.
Yeah.
So that the only issue that was left was the certificate of compliance issue on height. That was the whole purpose on us embarking on this. And this has just taken so long, and because it's a serious issue to be sitting there with an abatement notice.
Oh yeah, it is.
So that the whole purpose was just clean it all up, and the neighbours can get their acoustic fence. At the moment, where they haven't even got that.
Yeah.
So we've got to get these things cleaned up.
Yeah.
Separate, that's.
Yeah. No, that's understood.
Did you, Rachel suggested that we provide some additional or potentially additional word or condition or wording in relation to a land use condition for
the
height.
For the firefighting?
For the firefighting,
We can do that
so.
as our
That was a subdivision condition.
It just seems to be an issue that's a bit of tension between the land use and subdivision conditions.
I'm sure we can work through
So
that.
I'm sure you better work through that.
Yeah.
So just in terms of timing then, what's reasonable for you to, because you presumably you're going to need to go and ask Mr. Jorgensen for his monitoring information, then consider that, and if it is, as we say it is, you've got to come back with whether that makes a difference. So what time will you need for that, Rachel?
So today's Wednesday.
I'm asking.
I
suspect might be getting AES to review the work. It might be the key part of the time frame. Probably depends on them. We can't.
So what are they reviewing? I'm just wanting to ask the council's monitoring information to find out whether they're complying or not.
Yeah, if the council's monitoring information is been undertaken properly and with all the right equipment and it shows that it complies, I guess the issue is given that SCS complies, does that alter council's position on the appropriateness of the conditions?
Yeah.
So it doesn't need a full peer review. I guess it's just here's the information that we've done. This has been properly obtained.
Yeah.
Does that factor into your recommendation or not? It's just closing out that loop.
So it's really just confirmation of what we've said about compliance or not, and subject to that, does that change?
Does it make a difference?
Yeah.
And bearing in mind, you might take a bit of time to think about it. And I mean, I don't know, is the end of next week reasonable?
That's what, I was thinking.
So Friday, given today's Wednesday.
Well, if you can do that by the end of next week, and then we can come back, a week later.
Yeah, and obviously, if you need more time,
we won't.
I'm happy to issue a pretty brief minute just around that, but if everyone's happy to work on that basis.
Yeah.
And obviously, if it comes earlier, then that's good. All right, is that nothing else you wanted to cover off?
No.
I think everyone's reasonably clear on what we want to.
We might just have a little bit, putting aside the shipping container and building issue, just have a look at how that condition 22 might be worded in any event, putting aside the should it refer to shipping containers.
Yeah. But in terms of
it might be able to be better. Yeah, it's just how you measure it.
Making clear compliance as opposed to an amenity issue.
Yeah.
I'm happy for that. Yeah, I can look at that as well.
I just say one thing. I'm a little concerned that the raw data from the testing should be provided, and I have a level of distrust. I would not like to see that raw data provided to someone to produce evidence post now with a view to justifying the position taken, ignoring that evidence.
Yeah,
it's very important that the raw data that was available when the decision was made should be made available without further research and report.
Yeah, that's what I was trying to get to say we're not reviewing, or
we're not going back,
looking at the district plan, we're reviewing
it's purely saying
how Fenwick's work. Do your enforcement department tell us it complies or not?
And if it complies, then does that change council's view in any way? Given that information doesn't appear to be made available to everyone at this point. So Yeah, and I understand the frustration and the.
Well, I would like to see that. I would like to see that data. We've just got a summary of it.
Yeah.
Are you, Richard, are you asking, for that question to be answered now on the basis that it does comply with
No,
it?
I don't think that's fair on Rachel. She's.
No, I wouldn't put someone on the spot like that.
No, I'm just conscious that I don't want that data to be referred to someone now for them to interpret it.
Yeah, no, understood. I understand. Yeah, so no, the question is purely if the measurements have been taken, they've been done with properly calibrated machines, and it demonstrates compliance.
Do they comply or not?
Do they comply or not? And if
Yep.
so, either way, does that have an effect on the recommendations or the view of the appropriateness or otherwise of the conditions?
The newsletters to the community that we've seen suggested. Yes.
Yep. Well, I'm happy to issue a minute. This is A, the information can be circulated to everybody. B, there's a council response to that by the end of next week. And then applicants closing by the end of the week after. And obviously there's more time available if you need it.
Yeah, and we'll tweak some of those.
Yeah, and obviously discussions around those other conditions.
Yeah, and the LGA condition, I think. So Mr. Templeton has a separate legal counsel, so I will get them involved in dealing with how we lock in your requirement to provide a waste management plan and what the best process for doing that is.
All right, thank you. Nothing else? I think we've covered everything.
Thank you very much for your time.
Yeah, no, thank you. It's been interesting.
Really appreciate it. And council as well.
No, I appreciate this has been a long running issue. It'd be nice to get to a resolution of sorts. So thank you everyone for coming, your presentations and the information provided. It has been helpful. So thank you.
Thank you.